Good Saturday afternoon, everybody. Welcome to Bethea'S Byte Reloaded. I'm Ernest Bethea, the Last Outlaw. So good to have everybody here. And we got a lot loaded up this week, including not one, but two missing persons cases with two victims each. Having said that, let's go ahead and get started with our first missing persons update. On your screen right now is Amber Ayaz, if I'm pronouncing the name right. She's been missing since November 22nd, 2019 out of Irvine, California, alongside her daughter, Melissa Fu. All right, I'll break both of these down. Let me start with Amber first. There's the statistics. Let me pull that up on my end here. There we go. Oh, the FBI field office in Los Angeles, California, is seeking the public's assistance in locating Amber Ayaz and her daughter Melissa Fu. Amber was 34 years of age at the time of her disappearance. She has black hair, brown eyes, stood about 5 feet 9 inches tall at the time of her disappearance, and weighed around 180 pounds. She was last seen wearing a black shirt, black vest, fitted black pants with white writing, and light-colored shoes. Her daughter Melissa was 13 at the time of her disappearance. She has dark brown hair, brown eyes, stood about 5 feet 11 inches tall, and weighed around 200 pounds. She was last seen wearing a black tracksuit. Here's your details. Amber Ayaz and her daughter Melissa Fu were last seen on Friday, November 22nd, 2019 at approximately 6 o'clock p.m. at their residence located in the area of Peterson Drive and University Drive in Irvine, California. There are suspicious circumstances surrounding their disappearances, and two people seen in the vicinity of their residence near the time of their disappearance are being sought for questioning. The unknown individuals are possibly associated with a black Cadillac, unknown model. Those individuals are described as follows: a Chinese female in her 40s, standing approximately 5 feet 8 inches tall, with an average build, with black hair worn in a bun. And a Chinese male, also in his 40s, standing approximately 5 feet 10 inches, weighing around 190 pounds, with an average build and short black hair. If you have any information regarding the whereabouts of Amber Ayaz or Melissa Fu, please do not hesitate. You're asked to call 911 or contact the FBI's toll-free tip line at 1-800-CALL-FBI, 1-800-225-5324. You're also asked to submit your information to the FBI's Los Angeles field office. That number is 310-477-6565. Also, you can also submit your tips anonymously at tips.fbi.gov. As always, your diligence and information can be the difference maker in bringing both Amber and Melissa home safe and sound. I'm asking you to share this information with someone who may have valuable information that could bring both mother and daughter home. Next up, we got a report out of the FBI field office in Philadelphia, Pennsylvania. They're asking the public's assistance in locating Danielle Imbo and Richard Petroni. Danielle has been missing since February 19, 2005 out of Philadelphia. She has a date of birth listed as August 7, 1970. She has brown hair, hazel eyes, and at the time of her disappearance, she stood about 5 feet 5 inches tall and weighed around 117 pounds. She was last seen wearing a dark-colored jacket, cream-colored sweater, and blue jeans. She wore three small silver rings on either her left or right middle finger, and she was also carrying a two-handled black purse. She has tattoos of flowers on her lower back. Richard Petroni is also missing. They have a date of birth on him as August 29th, 1969. He has brown hair, blue eyes, and at the time of his disappearance stood about 5 feet 9 inches tall, weighed around 200 pounds. He was last seen wearing a gray Polo brand sweatshirt and blue jeans. He has a tattoo of the word Angela on his left arm and a tattoo of clowns on his right arm. Danielle Imbo, who may also go under the name Danielle Otobre, also worked as a mortgage loan officer. Let me get the rest of the details back up in front of me. Danielle Imbo and Richard Petroni were last seen leaving a bar and restaurant in Philadelphia in the late evening hours of February 19, 2005. The two were dating. They have not been seen nor heard from since this last sighting. Petroni's vehicle, a 2001 black over silver Dodge Dakota pickup truck with Pennsylvania license plates YFH 2319, is also missing. There may be a NASCAR sticker in the rear window. The FBI is offering a reward of up to $15,000 for information leading to the arrest and conviction of anyone involved in the disappearances of Danielle Imbo and Richard Petroni. If you have any information regarding the whereabouts of Danielle or Richard, again, please do not hesitate. They're asked to call 911 or contact the FBI's toll-free tip line, 1-800-CALL-FBI, 1-800-225-5324. If you want to submit your information to another source, you're asked to call the Citizens Crime Commission's tip line. That number is 215-546-TIPS, 215-546-8477. Or you can also submit your tips anonymously at tips.fbi.gov. Again, your diligence and the information you provide could be the difference maker in bringing both Danielle Imbo and Richard Petroni home safe and sound. Please share this information with someone who may have valuable information that could bring Richard or Danielle home. So now you got the information for Amber and Melissa. You got the information for Danielle and Richard. Share this information. Let's do everything we can to bring them home safe. Remember, if you see something, say something so we can do something. Danielle, and Amber. Alright. Like I said, we got a loaded lineup today. So we're going to go ahead and get started with an update on the mistrial. Alright, the prosecutors in the Karen Reed case are arguing against dismissing any charges. Here's a breakdown in that. Prosecutors in the Karen Reed murder case filed a motion Friday arguing against, now that's as of Friday the 13th. No, excuse me, Friday the 12th. Arguing against dropping any charges after her mistrial. Reed was accused of ramming into her Boston police officer boyfriend with her SUV and leaving him for dead in a snowstorm in January 2022. Her 2-month trial ended when jurors declared they were hopelessly deadlocked and a judge declared a mistrial on the 5th day of deliberations. The defense said she abruptly announced the mistrial without questioning the jurors where they stood on each of the 3 charges Reed faced, and without giving lawyers for either side a chance to comment. As far as a chance to comment, the only comment they really needed was, Your Honor, I'd like to poll the jury. Go with each charge. Prosecutors described the defense request to drop charges of second-degree murder and leaving the scene of a deadly accident an unsubstantiated but sensational post-trial claim based on hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. Contrary to the defendant's claims, throughout the jury deliberations, the defendant was given a full opportunity to be heard. The jury's communications to the court explicitly indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial, the prosecutors wrote. The jury did not reach any verdicts, partial or otherwise, prosecutors wrote. Reed's defense filed motions asking for the murder and leaving the scene charges to be dismissed. They contend that 4 jurors had said the jury had unanimously reached a not guilty verdict on those 2 charges. They said the jurors reported being deadlocked only on the charge of manslaughter while operating a motor vehicle under the influence of alcohol. Trying her again for murder would be unconstitutional double jeopardy. As they push for a retrial, the defense wants the judge to hold a post-verdict inquiry and question all 12, if necessary, to establish the record they say should have been created before the mistrial was declared, showing they unanimously acquitted the defendant of 2 of the 3 charges against her. The prosecutors argued the defense was given a chance to respond, and after 1 note from the jury indicating it was deadlocked, told the court there had been sufficient time and advocated for the jury to be declared deadlocked. Prosecutors wanted deliberations to continue, which they did before a mistrial was declared the following day. Contrary to the representation made in the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial, as she had adequate opportunities to object and instead remained silent, which removes any double jeopardy bar to retrial. That's what prosecutors wrote in their motion. Karen Reed, who is a former adjunct professor at Bentley College, had been out drinking with her boyfriend, Officer John O'Keefe, a 16-year member of the Boston Police Department, who was found outside a Canton home of another Boston police officer. An autopsy found O'Keefe died of hypothermia and blunt force trauma. The defense contended O'Keefe was killed inside the home after Reed dropped him off, and that those involved chose to frame her because she was a convenient outsider. Ladies and gentlemen, I say again, I say this with everything within me. They should have polled the jury before the mistrial was declared. I mean, how hard is it to ask each member of that jury on count two, what is your verdict? Because the reason you ask that way, because you already know there are some members of that jury that will tell you this is my verdict for this charge. This is my verdict on this charge. This is my verdict on this charge. Where you have 11 others either agreeing or disagreeing with you which is how we get a deadlock in the first place. Excuse me. And there was so much. Oh, dude, there was so much that was mishandled. I can't even. I'm already yawning over the fact of it that I'm still covering this thing. But that's my dedication to this case. And when we get more information as to if and when a retrial is going to go down, you'll get that information here first, here at Bethea'S Byte Reloaded. Alright, moving onward. Here we go again. Last week, I made mention about a child who died in a hot car. Oh, who we got here? Jennifer Anyhole. How you doing, Jen? All is well, thank you. Good to have you here. Here we go again. Last week, I made mention about a child died in a hot car. Now, we have a dad charged with murder after his daughter dies in a hot car. Guys, I will unleash my venom after I give you the article. So I'm gonna step myself out, but I'm gonna let you hear everything in this article. Okay. You're in Arizona. You're in Arizona. Arizona, you are already in hot weather during the summertime. Who knows how hot it is outside? But whatever that temperature was around 1 p.m. around that time in Arizona, tack on another 20 degrees for 3 hours. Common sense, parents. Why do you think I do this every summer, right around Memorial Day? I drop a PSA every year during the summer, right around Memorial Day, telling you always, do not leave your child in a hot car. This is the end result. I don't care if your child is asleep in the back seat. You get her out of the car. You get him out of the car. Now, we got a dad about to go to court with pretty much his life on the line because he foolishly left his child in the back seat for 3 hours simply because 1, she's asleep, 2, the car is running, 3, the air conditioning is running. Did you ever think that there was going to be some point when all that would stop running? Maybe this will be the wake-up call Christopher Scholes needs. In my mom's immortal words, God bless her soul, and I love you, Mom. A hard head makes a soft behind. Up. We're going to take you to a Boston courtroom. We're going to take you to a Boston courtroom where a former Boston attorney, who was once named one of People magazine's most eligible bachelors, has been sentenced for a rape conviction. Stand by.
Now turning our attention to the rape case against former prosecutor Gary Zarola. Former attorney is facing sentencing after being convicted of rape last month. Prosecutors say after a night of drinking, Zarola entered a 21-year-old victim's apartment, and when she woke up, he was raping her. The victim was not present for today's sentencing, but the prosecution told the court that that was no reflection on the case. Let's head back into court for more of that hearing.
He also, with a Boston police officer, Andrew Biggio, started the Boston Wounded Veterans Charitable Motorcycle Run. They raised a lot of money for veterans that had been wounded. I know you have the letters. I wanted to make a quick comment on that because and I don't mean to suggest that the government tried to assert a negative from it, but irrespective of someone's past, the court should consider whether or not there will be a support network, and there is. And this is a support network that Zarola has earned over the course of his lifetime. These people didn't just show up for the heck of it or because they had nothing better to do. You might recall a letter from a Robert Walsh. Robert Walsh had a conversation with Mr. Zarola one day, And he had mentioned to Mr. Zarola that friends of his that Mr. Zarola didn't know had no home heating oil. And Mr. Zarola, without any prompting, paid the bill for the home heating oil. Now, Mr. Zarola didn't do that because he thought someday that would help him before Judge Ames at a sentencing hearing. Mr. Zarola didn't send out press releases regarding that. And that was only one out of thousands of similar acts. Mr. Zarola did it the way it should be, silently, because it was the right thing to do. I can tell you, as early as this morning, I was telling people that Judge Ames is a stickler for deadlines. The deadline has come and gone for the sentencing memo because I was still receiving letters. I don't want to hyperbolize, but I'm probably at about 100 letters right now sent in support. And these come from all walks of life. These comes from...
Counsel, if you wish to submit further documents, letters, or anything else, I'm happy to receive.
Thank you. I knew that you would probably, knowing that you're diligent, had read the memos. I didn't want to be sending things at the last minute because I didn't want the court to think that I didn't take your deadline as serious. But the point being is, sure, some of these are clients that he skillfully got out of harm's way, but a lot of them are clients that came to him and said, I can no longer pay you. And Mr. Zarola, I've never come across a client where he filed a motion to withdraw because money became an issue. There are neighbors, there are people that were friends with his mother is of failing health. She's too old to come, but one of her sisters has been here every day, and Mr. Zarola refers to her as his mother. And these are people that he has, again, earned this with. So that's certainly something the court should consider. The court should consider not as a negative, conversely, as a positive factor, Mr. Zarola's age. And I'm going to say a little bit more about that like this. You know, when you're trying to formulate what an actual number is, and you do not necessarily a quantitative, but a qualitative analysis, there's really two ways to do it, right? You can assign each day a unit, and there's two ways they do it in mathematics. One is they call it a constant, but two, they call it a variable. And I'm asking you to consider it as a variable. And what I mean by that is not every day in prison, incarcerated, is the same. Not every day that Mr. Zarola is presumably going to serve, because we haven't even asked for probation, is going to be the same. But if you extend that argument, not every prison day is the same for every person. And what I mean by that is, if you were a 25 or 26-year-old with a clean bill of health, and you were being sentenced to prison on a drug or gun-related offense, that is still going to be a very difficult time. I go to these prisons. I've never served a prison sentence, but I hear the stories. I see the stories. Prison, despite what some people might see or read or hear, is a very difficult place. It is a violent place. It is a scary place. It is a psychologically traumatizing place. Criminals are not coddled, and I don't care what any member of the media says to the contrary about that. So as difficult as that would be for someone, say, 25 or 26, that's going in on a gun offense, think of how difficult that is going to be for someone who is 52 years old, and let's not ignore it, going in convicted of a sexual offense. Mr. Zarola, I didn't know him when he was 25, but certainly is now 52 years old. You know from the pleadings that he has significant health problems. He is suffering from a rare and aggressive form of eye cancer, ocular cancer. And Mr. Pallenbaum, and I don't think that he did this nefariously, but suggested that there will really be without limitation his treatment. That couldn't be further from the truth. Mr. Zarola sought and received treatment in Massachusetts for his eye cancer, and despite having some of the best and brightest people in the field in the entire world, even they said it was too rare for them and they didn't feel comfortable because they didn't have enough experience treating it, so they had all recommended and referred him to Dr. Shields in Philadelphia. Now, you know, Judge, that he had went and saw Dr. Shields, and Mr. Zarola did not want to further delay the trial for anyone, and we didn't press after the court was gracious enough to let him take that appointment to seek any further delay. But Dr. Shields, although certainly while she confirmed the findings that the surgery was not successful, that cancerous malignant tumor remains in his eye, and she did cite some growth, but not, overnight growth, still her prognosis is fairly dire, and the recommendation was for Mr. Zarola to go back to Philadelphia as soon as he can. No rape is good. And so while I don't minimize that, what the jury found, that, again, we can't, and I agree with the Commonwealth, we can't parse out or extrapolate exactly what they were thinking. We don't know if they found that she was actually awake, but the stupefaction instruction had some credence to it. We don't know. But we do know that no rape is good rape, but the allegations, to the extent that they were proven in this case, certainly don't distinguish them from another type of rape, a rape where perhaps a woman is accosted in an alleyway, or a woman is forcibly raped and suffers beating during the rape. So there's nothing unique about these facts that would warrant such a departure, and it actually cuts against all of the work that the Guideline Commission did. To the contrary, and I don't think age should play a role, but to the extent, again, there is optics involved. If there were two college kids in a similar circumstance in this case, I'd probably be asking for house time. Now, when we talk about, one other thing I wanted to talk about is rehabilitation. Certainly there was evidence of alcohol use and drug use by Mr. Zarola as well. And that's something that the guidelines talk about the court should consider. Mr. Zarola has been on conditions of release since the inception of this case for the better part of three and a half years. He was outfitted with a scram device, and he was required initially, I believe, 4 times, and it was reduced to 3 times when the medical issues came up, to have his blood alcohol content or his through sweat, whatever the scram device monitors, tested. Probably estimating about 3,000 scram tests were performed, and not on a single occasion did it detect that Mr. Zarola had consumed even a sip of alcohol in 3 years, which shows that he recognized the seriousness of the offense that he was charged for. He recognized that a judge, and I don't believe you set the first conditions, but that it was an order of a court he had to follow, and he followed it. And he followed it to a T. And certainly, DOC has done a much better job in getting progressive with addressing rehabilitation. I know, again, anecdotally from other clients, there is now meaningful opportunity for him to afford himself of all kinds of counseling. Obviously, with his degrees, he doesn't need the vocational training. He would take it if he could. They'll probably have him be a teacher. But certainly there is dual diagnosis, there's substance abuse, drug abuse, alcohol abuse, anger abuse. There's as much programming as the person wants. And knowing Mr. Zarola, he will be ambitious about it, he will be vociferous about it, he will be prolific about it, and he will do that. But the point being is the court has a pretty good body of evidence over the past 3 years that you're outfitted with a bracelet, you're on home confinement, you cannot have a sip of alcohol, and he's done it. And I know that I've talked to his probation officer. He is dutifully reported in person, by phone. He's coordinated with them the medical treatment, everything he was supposed to do. So there's a pretty good history that he knows he can't drink. He knows rehabilitation has to be part of the process.
The defense attorney there treading really lightly with the judge, trying to give his definition of the difference between a date rape and, to use his word, an alley rape. But he runs the risk of inflaming this judge, of trying to say there are levels or a lesser type of rape. When we come back, the defense attorney is going to wrap up his argument, and then we'll watch together the judge's ruling. Keep it right here on Court TV, your front row seat to justice.
Tonight in closing arguments, Ashley Benefield is days away from going on trial for shooting her.
Welcome back to Court TV Live. We are wrapping up our coverage in the sentencing hearing of a former prosecutor, Gary Zarola. A jury convicted him of rape last month, and his attorney, as we're watching, is wrapping up his argument for leniency. And after that, the judge will issue her ruling.
2 to 3 years is going to be exceptionally, and I know his family members probably don't want to hear this, 2 to 3 years is going to be exceptionally difficult and dangerous for Mr. Zarola. He is going to probably, on a daily basis, have to deal with comments, some of them on the threatening side. He probably, on too high of a frequency, is going to have to deal with physical confrontations, and he's going to have to survive. He's going to have to survive the cancer, and he's going to have to survive for the charge for which he stands accused of. The parsimony principle is something that's been recognized in federal court, and I believe in language, Rodriguez and some of the other cases in state court, that stands for the proposition that a sentence should be sufficient but not greater than necessary. Again, every day is difficult. I respectfully ask that you sentence to Mr. Zarola to no more than 3 years, no less than 2 years in state prison. And I know it has no legal binding authority, but I ask that you recommend Norfolk, because I believe they probably are the best equipped medically to deal with patients that have serious conditions.
Thank you, counsel.
And my client, one last thing.
Sure.
I don't want and I know your experience, you won't take it as a lack of contrition. Obviously, with a pending appeal,
yes,
Mr. Zarola cannot get up and make any type of statement. And I know you know it. You've been doing this for a long time, but I have to say it. Please don't mistake that for
I
a
was
lack
going
of
to
contrition.
ask you if he wished to allocute.
He does, but I've advised him that he cannot.
And that is not surprising, and this court, it's probably a very prudent step. And I understand that that doesn't mean that he doesn't wish to speak, but at this point with an appeal pending, ought not to speak.
Thank you.
Thank you very much. I have read very carefully and repeatedly and considered the memoranda of the Commonwealth and the memoranda of the defense. I have now listened very carefully to the statement of the victim in this case, and I have read more than once the letters of support, particularly the letter of the brother that laid out the circumstances of Mr. Zarola's life. I have also considered the acts and circumstances for which he was convicted in this case. It is this court's judgment that a sentence of not less than 5 years, not more than 10 years, is warranted by these facts, and the court imposes a sentence of 5 to 10 years in this case. Madam Clerk.
Thank you, Your Honor.
No, impose everything.
Okay.
Please.
Thank you, Judge.
You're welcome.
Mr. Zarola, as required by statute, I must inform you that the records regarding the charge for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court, unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you must use the request not to seal form. A copy of that form has been left with counsel at defense table. I cannot accept the form here in court. You must submit that to the Commissioner of probation at the address provided on the form. Please be aware that records regarding the charges for which you have been found not guilty are sealed. You will be unable to access the sealed records of the not guilty disposition or any records regarding to those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request those copies from the court within 10 days. Do you understand that, Mr. Zarola?
Yes, Madam Clerk.
Okay.
The record shall also reflect, and then I'll give you a chance to impose the sentence, that it is the court's recommendation that the sentence be served in Norfolk County. Go ahead, Madam Clerk.
Mr. Zarola, the jury having returned a verdict of guilty as to indictment number 2184 CR 00072 to offense 001 to the lesser included offense of rape. The court sentences you today to a term of not more than 10 years, not less than 5 years. That sentence to be served at Norfolk at your request. The court is imposing the DNA fee of $110 as well as the victim witness fee of $90. You're being notified that pursuant to Rule 64, you have a right to appeal this sentence to the appellate division in writing within 10 days, and that's pursuant to Rule 64. You're also being notified that you have a right to appeal the conviction within 30 days pursuant to Superior Court Rule 65.
Attorney Gary Zarola there, you see him discussing things with his attorney. He understands this process well because he himself is an attorney. Let's bring in two trial attorneys to help us break down what we are seeing here. Wendy Patrick and Michelle Thomas are with us. Michelle, your thoughts on 5 to 10 years for this defendant who was convicted on one of the charges but acquitted on the top ones, the aggravated rape and the burglary work he was acquitted on, but convicted on the rape charge against him.
Good evening, Julie. I think that was appropriate. I mean, the defense was asking for just 2 to 3 years under the, I think, mitigating factors argument that jail was too harsh for him and he had a great support system and this rape occurred. It wasn't the same type of rape that occurs in an alley. And quite frankly, those arguments are offensive. Rape is rape. And I'm quite certain that this 21-year-old victim at the time felt that she was in danger and felt that she was should not have been subjected to the horror that she experienced that's going to haunt her for the rest of her life. So I do think that the 5 to 10 year range is appropriate. The court certainly gave consideration, giving him the recommending a specific facility that he requested. He is a former attorney, but I think that that's really an appropriate sentence given the crime of which he was convicted.
Yeah, Wendy, this is a defendant who asked about getting a specific placement when it comes to where he's going to serve out his sentence because of an eye cancer that he has. Is that typical that a judge approves that, as it seems like has been done in this case, or the Department of Corrections approving where they want to go? And anything else standing out to you about this particular sentencing?
That remembering my years as a criminal defense attorney, this has got to be one of the most challenging types of sentencing hearings that you appear at when you're talking about rape, sexual assault. There is no way to describe it that is not offensive. This is one of those crimes that across the board, I mean, criminal defense attorneys are just as disgusted. They have families too. So what you heard here was good guy evidence. He's a former lawyer, he's turned over a new leaf, he doesn't drink, and really trying to mitigate this case through proving credibility through compliance. He's done what he's supposed to do. He's following the rules. But it's just so hard to undo something this significant, especially, you would think that having this type of a career would be a mitigant. It's an aggravant. It's one of those things that you just can't argue it away. This is somebody that should have known better. And to talk about, well, he's not the same kind of a person when he drinks versus doesn't drink, that's a dangerous proposition should he have a drink again. So I think the judge, given her experience, did probably what the defense attorney and his client already knew she was going to do, is didn't impose that lesser sentence because you got to consider the victim and the facts of the case as well.
Her Honor has spoken and the appeal is pending. So we will see what happens next for Gary Zarola as he is now going to be moved into this incarceration that he's been sentenced to. Michelle and Wendy, stand by. We are going to shift our
As we ended that video, the judge has officially sentenced Gary Zarola to 5 to 10 years behind bars. Let me know if you think justice is served on that one. Alright, let me adjust my camera a little bit. There we go. Now you can see my face instead of just my mouth. And maybe I'll adjust the light a little bit too. There we go. Now, we're going to move onward. And if anybody is following the Young Thug Rico case down in Georgia, and you're actually pulling for Young Thug to come through, you might have a little bit of good news coming out of this one. The judge has been removed from that trial. The judge overseeing the long-running racketeering and gang prosecution against rapper Young Thug and others has been removed from the case after 2 defendants sought his recusal, citing a meeting the judge had held with prosecutors and a state witness. We're gonna take you back to that. I'm about to take you back to that ruling right now.
The YSL RICO trial of rapper Young Thug is on pause indefinitely as Judge Raul Glanville has been removed from the case. Defense lawyers for Young Thug and for another defendant joined with his case argued that the judge should no longer be presiding over the case because of an ex parte meeting. You'll recall this, we told you about this, that he had with prosecutors and with the prosecution witness. It did not include the defense attorneys. Young Thug's attorney, Brian Steele, was then held in contempt. You'll remember that as well, I'm sure, when he questioned the judge about it and wouldn't reveal how he learned about that private ex parte meeting. So now Brian Steele still continues serving his sentence. I mean, he's serving jail time on weekends with his client, Young Thug. What a legal hero he is, but that's beside the point. Now, this case was referred to another judge to decide about the motions requesting recusal. That judge said yes. While she believes that the Honorable Raul Glanville would be able to continue presiding over the case fairly, she said, in order to prevent the appearance of impropriety and maintain integrity of the system, we're going to ask him to step aside and we're going to reassign the case to another judge. So now we wonder, is this the beginning of the end for this case? I mean, this case that started back in 2023, this case that took 10 months to pick the jury, this case where there were upwards of 20 defendants initially, and they're being referred to as Atlanta's most violent street gang, and yet most of them have been offered plea deals of probation to plead out, and some of them being asked to give testimony. Let's talk about what's going to happen with this. I want to bring in attorneys Melba Peterson and Matthew Mangino to talk more about this. What a mess this case is. You both, what a mess. It's just, what a train wreck. Melba, would you start us off, please? Do you think this could be encouraging for Thug and the other defendants here getting a new judge?
I think that that's going to be a mixed bag, because you sort of like, it's the devil you know, right? So not calling the judge devil, but just saying at least you're kind of more aware of the way he rules on certain things. They've basically spent 18 months together, you know, even more in terms of pretrial motions and all of that. So they've kind of gotten into a rhythm with him. Now they have to learn a new judge, their personality, how they're going to rule on certain things. So that can be a mixed bag. But it is encouraging, especially from the fact that the trial had taken so long. Now you're getting a new judge. That may expedite things to be able to bring you closure and get to a verdict even faster. So I think it could be a mixed bag either way for them.
Yes, I think you said the word everybody was hoping to hear, expedite. Melba, thank you for that. Matthew Mangino, I mean, your thoughts on the length of this? What a mess. What do you think about the new judge coming in?
Well, really, it's extraordinary to switch judges in the middle of a trial. And here, the idea that this judge would have an ex parte meeting with prosecutors and a witness without the defense being present, really brings into question his judgment. And obviously now he's no longer involved in this case. And as you said, the case has been dragged out for months and months. And, maybe a new judge who's going to have to get up to snuff on this case very, very quickly and review what's happened in the past, because sometimes certainly what's happened in the past is going to have an impact on how this trial moves along. Motions in limine and things like that, that the former judge dealt with throughout this trial, and all of a sudden a new judge is stepping in and has to become aware of all those things to keep the trial moving and to understand how things should progress in this case. So it really is going to be interesting to see how things evolve as a new judge comes into this case.
Right, Matthew. And when we think about the length of time, I liked what you said there, Matthew. You said it's extraordinary to have the switching of the presiding judge right in the middle of things. How about the length, too, of just the jury selection and the length of this trial? I mean, we have broadcasted some of it, but we couldn't possibly show the whole thing. I mean, there's no end in sight. Melba, curious what you think, assessing the state's case. Of course, they've got the burden. Do you think there's a precision problem here? Your thoughts, please.
Yeah, I mean, definitely the length is problematic because you have the issue of the jurors being, regular people, and they have to now remember what was said at trial 10 months ago, right? So if you're not taking copious notes during the course of the trial, you might forget different details, and that can impact how the deliberation process will go. Not to say they can't have portions read back, but if you can't even remember where to go, you don't even know where to ask the court reporter to go back to in order to get that particular testimony. So, I don't think that this is really helping the state's case, the length of time that this is taking. It definitely benefits the defense, but, we'll see how this goes, because it's definitely a mess.
Exactly. And we will keep on watching. Melba Pearson, Matthew Mangino, we always love having you both on opening statements. Thank you for everything this morning. We'll see you soon.
Wait to see what occurs next in the YSL trial, and who this new judge will be, and how this is going to affect the case. Of course, I'll have the information here. Next up, Laci Peterson's mom is speaking out as Scott Peterson is still pushing for a new trial. Shannon Roca has let her feelings about former son-in-law's bid for a new trial be known. That is what made me sick when that indictment went down. That made me sick to my stomach. Now she's incompetent. She's incompetent to stand trial. I don't know what to tell you guys, but I'm hoping and I'm praying that she will be able to stand trial. And when that time comes, I hope she gets the sentence she is due. There's no good reason she stabs a 3-year-old to death. Next up, got another bad mom. Yeah. Mom charged with murder after drowning her daughter in a creek. Hendersonville, Tennessee. Hendersonville police are investigating the death of 7-year-old Piper after her mother reportedly drowned her in the water along a local greenway. According to officials, the mother, Brandi Nicole Elliot, stated that she wanted time alone after a rough day and that her daughter came outside and refused to leave her alone. Piper did not want to stay inside by herself. The mother then took the child across the street to the greenway. She said that since the victim would not, quote, give her what she wanted, time alone, that she would give her what she wanted. That's when Elliot repeatedly held her underwater until she felt her bubbling. She reportedly told the child to be quiet while she held her underwater. Deanna Sartain said, "This is not like the Brandi we knew." She is a friend of Elliot's, having worked together for several years. Sartain also knew Piper. She was always smiling. She was just a vivacious child, she said. Sartain said that on last Saturday, Elliot took Piper to visit her father in the hospital and everything seemed fine. They went there and Piper colored pages from a book to put on the wall. And 2 hours later, Piper had passed away. Is there any way you can explain this? What do you think could have led her to do this, we asked. I keep analyzing it, and there's nothing. I just don't get it, Sartain said. Elliot was charged with first-degree murder and is being held in a Sumner County jail. The district attorney didn't say if he would seek the death penalty in this case. A bond hearing is scheduled for Friday. It's coming, which was yesterday. And I still have more information coming, so stay tuned. More. Right back to the Scott Peterson case. Back to the Scott Peterson case, he was back in court trying to clear his name. This is the hearing that was wrapping up from Monday. So I'm gonna step away, and I'm gonna put you right in the courtroom for this for the conclusion of this hearing.
Thank you. So, Ms. Mitchell, let me give you an opportunity to actually make your comments about 813.
813, Your Honor, just with respect to the fishing expedition narrative that the prosecution is putting forward, there were over 10,000 tips. We have reviewed all of them. We have selected the tips that were among the 10,000, which appear to be material to this case, which actually appear to be corroborated by other evidence in this case. So it is not a fishing expedition to the extent that we are asking them to provide reports of interviews with witnesses who called in 10,000 different witnesses. These are very carefully selected. We followed up on them and we interviewed them. With respect to number 13, the teacher of Stephen Todd's son called and the tip line and reported that she had heard from the child that his mother had a history of selling babies in open adoptions. If they contacted that teacher and followed up on that tip, we would like that interview, post-conviction interview with this woman, who wishes to remain anonymous, said that after she called in the tip, she heard additional information from the child indicating that Stephen Todd was talking about knives and Stephen Todd was talking about cutting a baby out. This is the evidence we have. We're asking if anything in the Modesto police file or in the DA's file shows that they followed up with this witness. We would like that provided.
In your interview, did she say she ever talked to the police or they ever called her?
She said that, I'm trying to recall, Your Honor, I believe she said that she had not received a call from the police.
So what's the basis for thinking that the material that you're asking for under 1054.9, i.e. the police called in, if the witness that you're talking to, she said, I called the tip line, I tried to tell them what I knew, they never called me back, why do you think that there is material that would document that a police officer did something that the witness said didn't happen?
Well, witnesses are not always accurate, as the prosecution has stated over and over and over again with all of the eyewitnesses who reported seeing Laci Peterson alive on December 24th. So I would say that to the extent that this is evidence of the reasonableness of their investigation, that was not, has not been investigated prior to now. This is something that it's simple, Your Honor. If they don't have it, they don't have it. If it exists, we would have been entitled to it. If it doesn't exist, they can simply say it doesn't exist.
Okay. Thank you. Next item.
On item 14, the typewritten report by the polygraph examiner who interviewed Stephen Todd at Bates number 4161 says nothing about Stephen Todd being questioned about his drug use, his methamphetamine use. We have listened to the audio portion and watched the video recording of the polygraph examiner's interview with Stephen Todd, where he states that he uses drugs basically every day. It's very difficult to hear the audio, which is another reason we are asking for the polygraph examiner's notes or any other records documenting what steps were taken by the polygraph examiner or anyone else in Modesto Police Department to determine the extent of Stephen Todd's drug use during December 24 through December 26. As I stated yesterday, Your Honor, our defense investigator interviewed Stephen Todd in, I believe it was August of 2004 during Mr. Peterson's trial, at which time Mr. Todd stated, I was so high on drugs that week, I really don't remember much about the dates or words to that effect. If there is any other evidence in the Modesto Police Department or the district attorney's file indicating that they looked into his drug use during that week, whether he could accurately recall dates, which frankly he already demonstrated he could not when he initially told police that the burglary occurred on December 27th and that he was confused. Another piece of information that Officer Hicks left out of his written report, Stephen Todd said he was confused. So if there are any other notes or records that will help indicate the investigation into his drug use, we would like those records.
Okay. Comments by people, sorry.
Yes, Your Honor. Defense is relying on defense investigators' own personal interview with Stephen Todd that investigator nor Stephen Todd had testified. Additionally, the defense continues to shift the burden and put it on the people to go and fish through the files. They keep saying, if they're, what steps we're taking. We want a complete accounting of what the investigation is doing. It's a narrative they keep repeating over and over and over again without sounding redundant. If defense can pinpoint a specific report of this item existing.
Well, this is one where I just heard a Bates number where she said, what we want is the notes of the polygraph examiner to talk about whether or not they asked him about whether what his drug use was, or whether there was any reason they didn't. We know that there was a polygraph interview. We know that there were notes taken. I think this was, according to your argument yesterday, the subject of a prior motion under 1054.9, where a prior judge in that litigation told the defense that they were not entitled to that information because it didn't meet the standard under 1054.9, which you covered in your papers. So for this item, we know that there is certainly a reasonable basis to believe it exists, that there are other references in the record to the fact that this item exists. So you can continue your comments if you have any.
Outside of what would be the polygrapher's notes indicating are you currently under the influence or not before they conducted the polygraph, there's nothing else that the defense has pointed to other than speculation that there's additional reports, notes, or interviews that were taken by the on specifically asking him a thorough resuscitation of how long he's used methamphetamine or any of his drug history. So again, outside of what the defense has already stated they have, it doesn't fall into any other steel category.
Okay. Thank you. Next item.
Your Honor, I can cover 15 and 16 together. They relate to our request for any items of discovery relating to Donald Glenn Pierce's cell phone usage or purchase of a cell phone on December 24th. At Bates number 4121, the report states that when they executed the search at Mr. Pierce's home, there was in plain sight a receipt for a Nokia cell phone that was purchased on December 24th. Given that Mr. Todd and Mr. Pierce were in communication about the burglary of the Medina's home, if there were any cell phone records obtained that might indicate the dates or times that there were any cell phone conversations between Mr. Todd and Mr. Pierce, we would like those records. We do not have anything in the police reports indicating that Mr. Todd at any point telephoned Mr. Pierce, but if that evidence exists, we would have been entitled to it and we would like it. We would note for the record that law enforcement was certainly capable of obtaining cell phone records of every individual that they wanted to investigate in this case, as they did for many, many witnesses.
And it would seem, based on my experience, that if they had done so, they would have needed to do so pursuant to a search warrant, yes?
Well, they did execute a search warrant on...
Right, executing a search warrant on somebody's house isn't going to give you their cell phone records. Executing a search warrant on their cell phone provider certainly would. Had they done so, they would have filed a return in Stanislaus County Superior Court. Has anybody looked to see if there was a search warrant return filed, which would have been a public document, which would certainly tell me whether or not this was done?
That I don't know. I have not done that search, Your Honor. I know that there are a number of returns that we do not have.
So what's the reasonable basis for believing that the police actually obtained either Pierce or Todd's cell phone records for 815?
I guess I have none, Your Honor.
Thank you. And in terms of the receipt, that would essentially, the receipt is the thing that you're looking for because there is a document indicating that they seized it, and it would at least tell you essentially where you got the phone and potentially what the number was so that you might be able to follow up to see if the records exist from the cell phone provider yourself.
Yes, as well as his whereabouts, perhaps on December 24th, at what time he purchased the phone.
Sure. When the receipt was issued. Okay. All right. Comments by people on A15 and A16?
Just briefly on A16, 4121 does not state that they seized the Nokia phone receipt. What that report indicates, Your Honor, is that they observed a receipt with Glenn Pierce's name on it. They also observed Stephen Todd had a California ID in that room. What the cops were indicating is that this particular room belongs to these individuals because this is indicia in their names. It doesn't indicate in any of the reports that they seized that receipt. And the people have the Bates page if the court wants a reference to it.
The Bates page that I was provided was Bates 4121.
Yes, Your Honor.
That's right. Okay. I will look at that when we make a decision about this.
Okay.
Okay. Then item A17.
Officer Hicks of the Modesto Police Department indicated that he had prior contacts with Glenn Pierce and Stephen Todd. That was indicated in Detective Stow's and Detective Hicks's report at Bates 20362 and 4115. We are asking for any records or investigation reports, arrest reports, notes, or other documents that detail Officer Hicks' interactions with Pierce or Todd, as we have provided the court in with Carl Jensen's declaration. Mr. Jensen was able to obtain some of Mr. Todd's prior criminal records, which indicate that he did have a history of violent assaults, and any of that evidence would have been discoverable at the time of the trial, and the defense was not provided with it.
Okay. And there was reference yesterday, and I want to clarify this. Was there was reference yesterday to Hicks having made some kind of a statement, and I know Officer Hicks testified at trial. Was any testimony elicited from Officer Hicks at trial regarding essentially his opinion as to whether or not Todd or Pierce had a character for violence that informed his opinion about whether or not he thought they were a reasonable investigative lead for having committed the crime?
I do not believe he was asked about that, Your Honor.
Okay, so he did not say that at trial. That wasn't a statement. It wouldn't be, for example, this information wouldn't be something that would have been able to impeach a piece of testimony that he offered at trial had the defense had it.
I believe that's correct, Your Honor.
Okay. Thank you. Comments by people?
This is not a Steel 1 category because the defense cites specifically to the Bates pages they're referencing to, and the defense has failed to state how it would fall under Steel 3 other than just giving the conclusory statement, since neither Stephen Todd or Glenn Pierce had testified at trial, and Hicks was not asked anything about character evidence.
Okay, and in terms of the Steel category of had they made a specific request for it, would they have been entitled to it at the time of trial if they were offering a third-party culpability defense at trial, and one of the people that they were arguing was third-party culpable had a character for violence? Why would that not fall under the if they'd asked for it, they would have been ordered to produce? It would have been ordered to be produced at the time of trial category of Steel.
This would be an SDT that was available to the defense at the trial, and it still does not fall within the 1054.1 category. It's not under those materials, Your Honor.
Okay, thank you. Okay, and your comments on the next item is Rachel.
Thank you, Your Honor. Okay, with respect to 18, we're asking for records related to Stephen Todd's guilty plea in the Medina burglary case. As the court may recall, this would have been a third-strike offense for Mr. Todd. He was a two-strike felony awaiting sentencing And those documents are provided as exhibits to the habeas petition. I believe it's exhibit 30, exhibit 29 is the complaint, exhibit 30 is the change of plea, exhibit 31 is the abstract of judgment. So Mr. Todd was awaiting sentencing. He was going to receive a 6-year sentence. At the time he committed the Medina burglary and was arrested, he was charged with committing this Medina burglary on or about December 24 through December 26. That's what the charging document says, and that is at exhibit 29 to the first habeas petition. At the plea colloquy, which is exhibit 30 to the first habeas petition, Mr. DeStasso, not Mr. Todd, stated on the record that the burglary happened on December 26th. Mr. Todd never stated that the burglary happened on December 26th. It was read into the record that it occurred between December 24 and 26. Mr. DeStasso stood up and said it occurred on the 26th, and the date of the burglary, the date that the burglary actually occurred, is exculpatory evidence. We would like any plea agreements entered into, any incentives offered, not limited to plea negotiations, factual basis for the pleas, abstracts of judgment, custody records for Stephan Todd and Glenn Pierce, anything that would inform what was under that plea agreement, whereby instead of being charged as a third strike, Stephan Todd was sentenced to 8 years and 8 months.
And there's still another update on Scott Peterson to come, so hang tight, guys. Now we're gonna move forward to an update on the synagogue leader murder trial, Michigan versus Michael Jackson-Bolanos. And yes, guys, you heard that name correctly. I didn't mutter, utter, or stutter. That was the name. In fact, I'm gonna go right ahead and jump to the big update on this case, because there was a partial verdict declared in this trial. So I'm gonna step out of the way and I'm gonna let you all hear this partial verdict as it pertains to Michael Jackson-Bolanos.
Welcome back. We are following breaking news out of Michigan. Welcome back. We are following breaking news out of Michigan, where a partial verdict has been returned in the case against Michael Jackson-Bolanos for the death of Samantha Wall. We are going to go into the courtroom now. The judge has talked to the parties about a note that she received. Keep in mind, this jury said multiple times they were hung on this case, and another alternate juror was brought in. There was some movement. They returned today for the last day of deliberations. Let's go in.
A verdict as to counts 1 and 3, and people will have to make decisions as to whether they're going to retry those counts. And we're going to set a pretrial for let's see, when next week?
Yes.
2 weeks. How much time?
Sooner.
Next week. Look at my calendar for next week.
And Judge, I'd ask for at least a week, because 25th.
Thursday the 25th at noon?
Yeah.
that work?
That's fine, Judge.
Okay. So Thursday the 25th at noon, we'll have a pretrial. If there are any motions you plan to make, please file that as soon as possible, the written motions, and we will address everything then and set a new trial date if it's going to be retried.
And Judge, I may have missed this, but is the court going to formally enter an order declaring a mistrial on those?
Yes,
on those
I am
counts?
declaring mistrial as to counts 1 and 3, and I have the order in front of you.
Thank you, Judge.
And I'll acquittal on count 2 only, and PSI until next week, and I may just refer to PSI until I figure that out next week.
All right, there you have it. After 5 days of deliberation, they did come back on some charge 2. Let's bring in criminal defense attorney through these because it was pretty quick there inside of the courtroom, but locked on. Premeditated murder, though, they found him not as him guilty of this jury.
It is but that is defense, a mistrial or a hung jury. Decide we retry the case, make 18 charges against the defendant.
Heard that they're going to set up or premeditated murder. Sounds like they set out to. Her door was unlocked and admittedly took the stand and said he was breaking of not believing that he actually jurors believing one thing or another. So Rob, if you're the prosecution, do you go back to and talk about perhaps a deal on were clearly some jurors who did not want to give in on him being not guilty of felony murder?
If I was the prosecutor, I definitely would engage in conversations with the defense, but that would be after I found out what the split was. For instance, if it was a split for 10 for guilty, 2 for not guilty, I may not engage in conversations and we would just try it again. But if the majority of the jurors voted not guilty, then that would be something I'd have to think long and hard about if I was going to retry that case.
Yeah, we've had big questions about that here on Court TV, most notably with the Karen Reed trial, where there was a mistrial, and then a big question of did they have a partial verdict there in the deliberation room? The jury wasn't officially polled by the judge, so not sure if they're going to be officially polled there in Detroit, Michigan, a different jurisdiction, perhaps a different way that the judge handles it, but we will see, and of course, keep everyone updated on those developments out of that courtroom and case.
Again, we get a partial verdict this time, but still we still have a deadlocked jury on counts 1 and 3, and the judge did not ask for the jury to be polled on those counts. Could we be looking at a retrial? Maybe. We'll just have to wait and see what develops next in that one. Speaking of retrials, Hannah Gutierrez. Now, last week, if you all remember, Alec Baldwin's case was totally dismissed with prejudice. Now, Hannah Gutierrez is looking for the same thing. She wants her case dismissed, or she's seeking a new trial. And honestly, after seeing what happened in Alec Baldwin's case, I tend to agree. If the judge can catch the evidence that was withheld in order to dismiss Alec Baldwin's case, I don't see why Hannah Gutierrez's conviction shouldn't be dismissed too, or at the very least, she should get a new trial. But in all fairness, I'm going to step out the way, and I'm going to let you see why she is asking for a brand new trial or a dismissal.
Actor Alec Baldwin's involuntary manslaughter case has been dismissed. This morning, we're shining a light on how it may affect the case against his co-defendant, Hannah Gutierrez, who is currently serving an 18-month prison sentence for that same crime. Let's bring in a very special guest now. We're so pleased to have on the show Hannah's attorney, Jason Bowles. Jason is a former prosecutor and a criminal defense attorney now in the private sector. We saw him in action. He was sensational, representing her on really tough facts. Jason, good morning. It's nice to see you. Could we start, please, with the motion for a new trial that I was joking a little bit yesterday on the program saying, I bet you're on the way to get it filed ASAP. Tell us, has it been filed yet?
Good morning, Julie, and it's great to see you. And we will be filing that motion today. That motion is going to spell out in detail that we are seeking a dismissal or a motion or a new trial. As you saw, the judge very thoughtfully considered the evidence and the situation that developed a trial and found serious misconduct on the part of the prosecution in a discovery violation. And also in how they treated certain evidence, putting it into a separate file and not turning it over to the defense. That is just the tip of the iceberg that we will be filing in our motion today. We have learned about other serious discovery violations. And look, I mean, the biggest thing about our system, as the judge said, is ensuring the integrity, ensuring the fairness to everybody that comes before trial. We're all entitled to that. And we're going to be putting that before the judge.
Jason, my ears perked up when you said other discovery violations. So you're saying more than just the rounds that they chose not to test and not to disclose?
Absolutely, Julie. We have found now that we did not get a third expert report from their expert on the firearms. We did not get a completely new interview of Seth Kenney, which, as you might remember, Seth Kenney was one of the key witnesses, one of the key players in this whole matter. And we just found out last week that there were 900 new pages, approximately, turned over of emails and statements of witnesses in the trial that we would have been able to cross-examine them on. So it's actually beyond the pale. You cannot conduct a trial in an unfair manner as a prosecutor. You put it all out there and let the jury decide. But what happened here is we had things hidden from us, and that's not fair.
No. And you know this, Jason, from having served as a prosecutor. There are special rules that apply. Anything you get, you've got to turn over. You don't just get to pick and choose like they did in this situation that caused the dismissal for Alec Baldwin's case. Backing up a moment, did you say you were denied an interview opportunity with Seth Kenney? I wanted to make sure I'm hearing you correctly.
We actually interviewed Seth Kenney, and we had some of his interviews, but we got a completely new interview he had conducted with the prosecution that we never knew about. He made several favorable statements to Hannah, which are going to be in our motion, which we never had, and which if I had, I would have cross-examined him on a trial. It could have changed the way the jury saw his testimony, I believe. And, I want to highlight something you just said. The duty of a prosecutor is to do justice, and that's the first thing they teach you. Erlinda Johnson, in her interviews, did the right thing at the end of the hearing on July 12th. And you saw another version of that, which is the prosecution essentially hiding evidence and trying to win at all costs. And that is not the duty of a prosecutor. So we're going to be attacking that in our motion.
Right, Jason. It's about doing the right thing. I remember my mentor said that to me. It's the best job in the world because you get to come to work every day and do the right thing. And sometimes the right thing is withdrawing charges, amending charges, not proceeding with the prosecution. It's not about getting a conviction, as you know. I want to play a clip for you of Seth Kenney. This is where, during the motion to dismiss the case, he was called as a witness, as you know. Let's take a listen to some of what he said.
Did you provide props and ammunition to the set of the movie Rust?
I did.
Was that after you brought these back from Texas?
I do not know. I do not know when this bin came back to Albuquerque from Texas.
You drove it back yourself?
I did, but I did a few trips.
You don't remember the day that you brought it back?
Correct.
Okay.
It could have been before the shooting, could have been after the shooting.
the dummy rounds that you provided to the set of rust, did you personally ensure that they were all inert?
Absolutely.
Ooh, okay. So, Jason, this is huge what you're sharing with us this morning, that there were exculpatory statements he made about your client, Hannah, that you're sharing with us that the prosecution held back before you went to trial. So you had no knowledge of them, no chance to cross him. And then after you watched him on Friday, did he say anything contradictory to what he had said in those previous statements? I'm curious.
I think his testimony and story have changed repeatedly in certain important aspects. One of the biggest is we now know he came back October 12th, and he brought a box of dummy rounds to Sarah Zachary on that day. Well, that's 9 days before the shooting. So this testimony that he doesn't know when he came back, I find very suspect. I did at trial. I mean, there's gas receipts. Obviously, he had to fill up coming from Texas. He could have gone back and verified. That was an attempt to try to hide that he brought him back before. But now we know he brought him back on October 12th. And we've got several other statements there we're going to be able to present to the judge. Ultimately, what the jury heard was a partial version. And the prosecutors hid the full version. So we're going to bring that out in some of our matters in the motion.
I'm sure you are. This motion is going to be chocked full of multiple grounds for dismissal and, or a retrial, depending on how the court comes down. Jason, tell me, backing up a little bit, we heard a lot about this witness, Troy Teske, the retired police officer who was referred to even as a good Samaritan during this motion to dismiss hearing, who brought the rounds to the sheriff's office in Santa Fe and said, you ought to test these because I believe what I have here is the batch of rounds from which the round that killed Helena Hutchins came from. And he had them from storing ammunition for Hannah's dad, Thel Reed, who had lent ammunition to Seth Kenny, ammunition that Seth took possession of. I want to ask you something that came up. The prosecution was sort of pushing back during the hearing. You heard Carrie Morrissey saying, well, the defense knew about Troy Teske and they could have called him as a witness. Share with us why you didn't, please.
Well, and I'll tell you exactly why we didn't. I did know about Troy Teske, and we had been asking them for years, the prosecution for years, to come and pick up these rounds and test them. Troy Teske had rounds from the same batch that went to Seth Kenny on the 1883 set through Thel Reed. So we had been asking him, test these rounds and see if they match the live rounds from the Rust set. The sheriff wouldn't pick them up. Then in November of 2023, Carrie Morrissey interviewed Seth Kenny and said, we are going to have law enforcement come get them. So please preserve them. So that's what Troy did. He didn't do anything with them. He waited. We waited. Again, the prosecution never came and picked them up, never tested them. So the problem is they just denied the opportunity for us to determine if those matched the live rounds. At that point, there was not a reason to call Troy Teske. So at the end of the trial, we had them turn those into the sheriff, hoping that they would then test them. So if our appeal is successful, we can say we got through. The biggest question in the case is, how did those live rounds get there? The first part is testing that same batch, which they weren't able to do. They weren't willing to do, I should say. So instead of testing it, they hid it in a secret file, which that was inconceivable, and I never thought in years they would do that.
No, certainly not. I'm sure they are just full of regret and embarrassment today, as they should be. They should be more than embarrassed. Jason, is there anything else? I mean, there's so much here. Please tell us anything else you want to share, perhaps even your client Hannah's reaction to this. I'm sure you've spoken to her since the news of the dismissal broke. Anything you can share about what she related in terms of how she feels now?
I can tell you that she's very hopeful that the judge will hear her new motion, and this judge is very thoughtful, very considering of all the evidence. And look, all we're asking for is a fair shake here and a fair procedure, and we did not get it during that trial, unquestionably, what happened.
Yeah, this is, it's quite a shame. And you know well from serving on the other side, there's no reason why you didn't get that expert firearms report you mentioned, the statements coming from the other interviews that were done with Seth Kenney that are exculpatory and favorable for your client, and why you were not privy to this information. Regarding those rounds and why they sat on them and refused to test. Jason Bowles, thank you so much for your time and for waking up early for us this morning. We'll look forward to seeing you soon. Take care.
Let's see, Dippy Escapes is jumping in. Hey, how you doing? Good to have you aboard. So now the question remains: will Hannah Gutierrez get a new trial, or best yet, will she get those charges and her conviction dismissed? Stay tuned, folks, because things have only gotten a lot more crazier in this case. Next up. A defendant who's only worried about three things as he's awaiting his murder trial: coffee, candy, and comfort. Yeah, Stephan Stearns is only worried about coffee, candy, and comfort while he's awaiting his murder trial for the death of 13-year-old Madeline Sophia Soto. He's complaining that he is running low on coffee. His cell is loud, dirty, and uncomfortable. Stephan Stearns, you can worry about all that. Just remember, there are people serving a life sentence that you allegedly sentenced on your own. There are people serving a life sentence without Madeline Soto. Now that I got that little bit of venom out of the way, I'm gonna take you to this video. Likely is with my main man, 50 grand, the man with the legal plan, Vinny Politan. And my wife is already working on her coffee pitch. So let's go to the video right now.
For what's trending in true crime, jail emails between accused killer Stephan Stearns and his family indicate that they think that someone else was involved in the death of 13-year-old Madeline Soto. Stearns is charged with murdering and sexually abusing Madeline, who was the daughter of his girlfriend, Jennifer Soto. Now, the state attorney's office released a 64-page document of email correspondence between Stearns and someone who appears to be his mother. In an email dated June 25th, Stearns writes, quote, there is still perhaps a slim hope for my situation. I maintain hope that I might be able to come home once this whole nasty business has reached its end. To which his mother replies, quote, we all know, and the name is redacted here, we all know, was heavily involved in this. And I am disgusted that she is free and you are not, when this is not all your fault. You need to think about yourself more and her less. She sure isn't thinking of you and how she can help you right now. All right, so question now, are the walls closing in on Jen Soto? Does this change anything? We know she's still being investigated by police, hasn't been charged up to this point, Let's bring in our guest. Still with me, the Director of Prosecution Projects at Florida International University, former homicide prosecutor Melba Peterson. And want to welcome in criminal defense attorney and former district attorney Matthew Mangino, and forensic death investigator, professor at Jacksonville State University, and the host of the Body Bags podcast, Joseph Scott Morgan. Good morning to you all. Jennifer Soto, will she be charged? Want to get your thoughts on this. Matthew Mangino, our former DA, let me start with you, please.
Well, these emails appear to be maybe self-serving. This is an exchange between, Stearns and his mother. They indicate that somebody else is involved. They don't completely say, hey, you're not at fault. Somebody may share in responsibility here. But don't forget, there's videotape from his camera of Stearns sexually assaulting Soto. So it's not as though he has no responsibility here. But the police have investigated this matter and put a lot of work into this. And I think if Jen Soto was going to be charged, she would have already been charged in this case.
Okay, the fair point. Matthew, thank you for that. And we really don't even know the details of how Madeline died, the laws in Florida, her age as a child. There's a lot of questions about that. And Professor Joe, I want to go to you next on this point, please. When we think about the possibilities of how, I'm curious if you had the same thought as I did, that I immediately wondered if her death occurred during the course of some type of sexual assault.
Yeah, and that's certainly a possibility. And in any case like this, I can tell you that that the ME's office will have done a rape kit on her. And not just that, Julie, we have to look back over time. Remember, this familial, if you want to call it that, relationship that was going on inside this domicile has been going on for a long, long time. And so I don't know that you could really have a lot of indications that there was ongoing physical abuse, like where we see things like broken bones many times with children, bruises, this sort of thing. It's hard to really know at this point. The histrionics in this case are going to be so muddled because the situation has gone on for so long. Did he fly into a rage at that moment in time and take her life? And I think that when all is said and done and it is revealed specifically what was done to this child, many things will come to light and we'll see how horrific this is.
Most definitely, Professor Joe. Children, as we all know, deserve to be protected. And I think just what boils my blood is this was happening under mom's roof. He's living with mom and then mom lies for him. We know that when talking about the drop off at school and all of that, she wasn't honest. So I have so much suspicion for her. And then how about his mother defending him and wanting to implicate Jen Soto in the email, where I should say it seems to be his mother. We don't know for sure because it's redacted, but I mean, who else would love him in that way but a mother? Melba Peterson, last but certainly not least, let me get your thoughts on these emails and what may happen with Jen Soto, please.
Yeah, I mean, I agree with what my colleagues have said. I think that the investigation's ongoing, but if there was any evidence to link to the mother, she would have been arrested with a swiftness. So I don't see that unless there's new evidence that comes to light. I don't see that this letter is more than wishful thinking on the part of purportedly a mother who does not want to accept that her son is a pedophile.
Exactly, Melba. Sicko Stearns is what I call him after all of that evidence, as Matthew Mangino referenced. I mean, there was, just a plethora of sick, disgusting evidence that police say they found on his phone showing the abuse of Madeline, photos, videos. I mean, it is just unconscionable what happened to this precious child. And now he's complaining about his living conditions in jail. I want to show you all another portion of an email. He writes, quote, "The mat is flat, has very little cushion left. The cell is small, filthy, has some spots on the wall that appear to be bloody fingerprints. blah, blah, blah. He's complaining about his situation. We've heard complaints from him before, haven't we? Take a listen.
Temperature was down. Temperature was like a degree or two lower than it should have been. Wow. Cook regularly, sleeping on bare metal. The first night I was on a concrete floor with a roll of toilet paper for a pillow. Nothing else. Looking for a blanket or a pad to sleep on for like 2 days. I think they were supposed to do something.
That sounds rough, man.
Oh, you wonder what the sheriff's deputy is really thinking. I wonder if he's thinking, I'm having a hard time feeling sorry for this guy based on the allegations that we know. Let's bring back in our power panel. Matthew Mangino, back to you. Your thoughts, please.
Well, this sounds, a bit like a spoiled little boy. He's exchanging emails with his mother that, I hope to come home soon. The place is not very nice. No kidding. You're in jail. You've been charged with sexual assault and murder of a 13-year-old. You're not going to have the best accommodations. You're going to have reasonable accommodations for the circumstances, but no, you're not going to have a fluffy pillow. They're not going to come in and scrub the walls every day, and it's going to be noisy because there are a lot of other people who committed crimes who are sitting in the same facility that you are. So, it's sour grapes from a guy who just doesn't get it, who's a reprehensible, at least we know from videotape, sexual assault of a child and complaining about his living conditions. No sympathy here.
I'm with you, Matthew. No sympathy. Professor Joe, no sympathy. Is that what you say as well?
Yeah, insert sarcasm. He's a real Count of Monte Cristo, isn't he? Having to live out this existence that he currently finds himself in. I think that it goes to a bigger idea that many people, and I'll say that very, very broadly here, have given him a lot of latitude throughout his life, perhaps, that he thinks that he's entitled to certain things. And I'll leave it at that.
Like what you're saying there, Professor Joe. We'll have to leave it there for time's sake, but great comments from you all as per usual. Professor, we got to say goodbye to you. Thank you kindly for being on the show this morning, Professor Joseph Scott Morgan. We will see you soon.
And like many, I have absolutely zero sympathy. No, let me say it like I say it. I have zero sympathy for Stephan Stearns. The man is sitting in prison for the alleged murder and multiple SAs on Madeline Soto. And he's worried about coffee, candy, and his comfort while he's in jail. You have got to be kidding me. Again, I have no sympathy for the man. I will continue to have no sympathy for the man, and I hope that when his trial comes up, he's found guilty, and I hope he rots. Moving right on. While one is sitting in jail waiting for his trial to come up, and he's worried about coffee, candy, and comfort, we got another one who's flat out ready to stand trial, facing a life sentence. The Rachel Morin murder case will soon be underway. Her alleged killer will stand trial in October as prosecutors plan to seek a life sentence without a possibility of parole. Victor Antonio Martinez Hernandez, 23 years of age. Oh, thank you, my lady.
It's cold coffee.
Oh, that works too. My lady outlaw hooking me up with cold coffee. Cold coffee on a hot summer Saturday. Anyway, Victor Antonio Martinez Hernandez is facing half a dozen charges, including first-degree murder, rape, and kidnapping in connection with the death of Rachel Morin. And he's currently being held without bail. So, I'm gonna step out. I'm gonna let you get a look at how this case boils down, and you tell me what you think the chances of a guilty verdict look like. Remember, we are still in the summer of justice.
We want to turn now to the Rachel Morin murder case going on in Maryland. Her accused killer will stand trial in October as prosecutors plan to seek a life sentence without the possibility of parole. The 37-year-old mother of 5 was brutally raped and murdered last August while jogging on a popular trail in Harford County. Now, a massive manhunt spanning 10 months led to the arrest of 23-year-old Victor Martinez Hernandez. Now, the El Salvador citizen who entered the U.S. illegally several times was caught in Tulsa, Oklahoma last month.
It's been a long 10 months, and it feels like there was a point where it felt like maybe it just wasn't going to happen, you know? So we're grateful and relieved and happy that he finally is off the streets, that he can't do this to anybody else, and that justice will be served for Rachel.
Before they apprehended this suspect, I didn't know if we would ever have an end to this process. Now I at least know that a conclusion is coming, that this man is going to face justice. So that gives me a lot of hope. But as for Faye and the other children, you have to remember that even though he's caught, and that's good news, it's also a reminder of the trauma that they've been dealing with for the last 10 months. So this is also a very painful time for them as well.
The arrest, of course, did put Morin's family at ease, and they also announced some additional good news while speaking with Court TV's Vinnie Politan.
So Faye, she is pregnant, 4 months. She's due December 1st, and she's going to have a girl.
That's amazing.
So we're just blessed.
Rachel would be a grandmother.
Yeah.
That would be Rachel's granddaughter, will be your granddaughter, Matt. Well, that's another reason to smile tonight.
Now, that would have been Morin's first grandchild.
We still have some news to wait upon. Hopefully that news will be a conviction in Rachel Morin's murder. Well, I'll keep you guys up to date with everything that will go down in that upcoming case. An update in the Brandi Nicole Elliot case, where she's accused of drowning her daughter. I mentioned that case to you a little bit earlier. Well, this update, Brandi Elliot is denied bond. And honestly, I think that's a good decision. I'll let you take a look at the video work, and you let me know if you.
Now for what's trending in true crime, a Tennessee woman is charged with first-degree murder after allegedly drowning her 7-year-old daughter for not leaving her alone. Brandi Elliot told police she was having a bad day and just needed some, quote, time alone. But when her daughter wouldn't stop bothering her, police say she took little Piper across the street to a lake and drowned her. According to court documents, Elliot claimed that she held the girl underwater until she felt her bubbling and told her to be quiet. Nick Barris from Scripps News Nashville has more.
This is a park in Greenway in Hendersonville along Old Hickory Lake, where a mother and daughter would often come and walk, maybe feed the ducks. But what happened this time was almost beyond comprehension.
It's extremely shocking. I'm still trying to wrap my head around it.
Hendersonville police arrested 33-year-old Brandi Elliot on Saturday. She is charged with first-degree murder in the death of her 7-year-old daughter, Piper. Elliot told officers she wanted time alone after having a rough day, but that Piper would not leave her alone. So Elliot took her across the street to the lake and admitted to holding the child's head underwater until she stopped breathing. Piper later died at the hospital.
It's not like the Brandi that we knew.
Deanna Sartain is a friend of Elliot's, having worked with her for several years, and she knew Piper.
She was always smiling. She was just a very vivacious child.
Sartain says that on Saturday, Elliot took Piper to visit her father in the hospital, and everything seemed fine.
They went there, and Piper had colored him some pages for him to put on the wall. And then 2 hours later, Piper had passed away.
Police say murdered by her own mother. Is there any way you can explain this? What do you think could have led her to do this?
Yeah, I keep analyzing it, and there's nothing, Nick. There's nothing I just don't get it.
This case is horrifying. Now, this morning, we're asking the question, what would make a mother seemingly snap like this? We've got a great power panel standing by. Let's welcome them in.
I stopped right with that question that Julie Grant just asked, and I'm gonna bring my wife, my partner in crime, and the love of my life all in one shot. Lady Outlaw, Crystal Bethea, come on in, sweetheart. You heard this. The woman wanted some time alone.
That's bullshit, dude. You shouldn't have to kill your kid just to get alone time. That's ridiculous.
I totally agree. So I'm gonna ask you the same question that Julie Grant just asked.
Take her to
hold on.
The fire department, the hospital.
Wait a minute.
You don't want the child.
Wait a minute.
There.
Wait a minute. Let me ask the question that Julie Grant just asked. What would make a mom just snap?
No idea.
I mean, yeah, she wanted time. She said she wanted time alone. She said she didn't want to be bothered with her child. I get that. But your daughter is still gonna want mommy. Daddy's in the hospital. She's gonna want mommy. What do? You're gonna have to put you on the back burner. You're gonna have to put you on the back burner. I mean, I'm trying to analyze this like the neighbors said, and I can't. And every time I see little Piper's picture, I'm thinking, sure, I'm having a bad day.
You want that child? You wanted that child, and you shouldn't have done that.
Hey, look. This the little girl in the
Oh, she's beautiful.
Yes.
Okay.
Mom's having a bad day. The girl's father's in the hospital. Mom's having a bad day. Of course she's gonna want mommy. But this woman wants to be left alone. So she decides to take it upon herself to go across the street from where they live at to a creek and drown her.
That's bullshit.
I won't say it, but I agree with you.
Take the child to the hospital or to the fire department.
Or somebody.
Or somebody who cares or
The,
whatever.
the neighbor.
The neighbor to watch your child for a couple hours for you. You don't have to kill your child.
Thank you.
That's what babysitters are for.
Thank you. Thank you. You heard it from her first, ladies and gentlemen. You don't have to kill. You don't need to kill your child just to get time alone. And on top of that, which I'll probably bring up a little bit later, Brandi Nicole Elliot has got more legal issues coming. Stick around. I'll bring that information to you. Next, we have some sad news that the remains that were found were that of Caleb Harris. But they said that the investigators said that there were no obvious signs of homicide. This was breaking news as of Thursday.
Right now, it's going to be up to the medical examiner's office to identify the human remains. So that's where we're at right now.
The remains of missing college student Caleb Harris have been found and identified. This is according to police in Corpus Christi, Texas, who cited a DNA report. Now, this comes after human remains were recovered from a wastewater well last month. You may remember us telling you about that. And at that point, authorities were still waiting for a forensic analysis to be done before being able to make an identification. Now, this confirmation marks the end of a months-long search for Harris, who disappeared near his apartment in the early morning hours. Now, police say there were no obvious signs of homicide, although the advanced state of decomposition of his body made it impossible to make an identification or to find a cause of death. We're going to continue following this story and bring you any updates on the case of Caleb Harris as we have them.
And of course, when Court TV gets the information, you can best believe Bethea'S Byte Reloaded will be able to get that information and get it to you. All right, next up, an Ohio man has been sentenced in his fiance's death. Now, I have this poll set up on my community page. I'm going to let you in on. I'm gonna let you go watch this hearing as it goes down at a sentence, and you tell me in the comments or in the community section if you can find the poll. Is this justice served?
And all rise. The Butler County Common Pleas Court is now in session. The honor.
Mr. Burris, did you wish to call the case to order?
Yes, Your Honor. We're here on Sale Ohio versus John Carter. It's case number CR 2020-23-030345. By the court's docket this afternoon for sentencing. Defendant is present before the court along with all three of his attorneys, Mr. Lawrence Hawkins III, Mr. Christopher Pagan, and Mr. Jackson-Bolanos. Prosecutor Michael Moser is present. Assistant Prosecuting Attorneys Katie Blackmore and Brad Burris.
Morning, Your Honor. Afternoon. Good afternoon. Any reason why sentence should not be imposed or anything in mitigation?
No, Your Honor. Your Honor, as we go through this hearing, we're requesting our client be able to remain seated at defense counsel's table until the sentence is actually going to be presented.
That's fine.
For the record, Lawrence Hawkins III, along with co-counsels Chris Pagan and Jacob Long, here on behalf of our client, Mr. John Carter, for the record is present. We first want to take time to take in consideration, asking the court to consider the sentencing memorandum that was authored and submitted by Chris Pagan, as well as the letters of support that were gathered and submitted by Jacob Long. For the record, all the defense team has reviewed the pre-sentence investigation in preparation for this hearing. Our client will be waiving allocution today. Your Honor, mitigation, and I'll be relatively brief, but it's necessary to highlight a few things that have been gone over already. We want the court to focus on the law. There may be some emotional statements that come out today, and that's understandable. But at the end of the day, our courts make decisions not based on emotions, but based on the law. We want the court to make a decision based on the law today. The Ohio Revised Code 2929-11 states the purposes and principles of sentencing are to protect the public from future crime, to punish the offender, and promote effective rehabilitation. Using minimum sanctions, the court determines accomplish those goals without imposing unnecessary burden on state and local resources. The law requires the court to consider several things. We must first note that the offense for which our client is being sentenced is involuntary manslaughter, not murder, not abuse of a corpse. A sentence should not be harsher based on the original charges, but focused on the charge for which our client has pled. That offense is one that the commission of a misdemeanor was the proximate cause of Caleb Markham's death, not the commission of a felony. The law says a prison sentence in this case is not mandatory. The law says there is no presumption of prison in this case. The law says that a community control sanction would be appropriate in this case. The law says consider our client has taken accountability, as the prosecutor referred to at the time of the plea. This was a matter of showing accountability. Accountability and responsibility is something that should be considered by the court with regard to the disposition. The law says consider that John Carter has no prior juvenile record. He's never been sentenced to Department of Youth Services. The law says consider that he has no prior felony record. He's never been sentenced to prison. The law says the court should consider the fact that the only record he has is a low-level de minimis misdemeanor from years ago. The law says consider the fact that the 14 days that John Carter was incarcerated on this case is the only time he's ever been incarcerated in his 36 years of life. The law says consider the fact that over his 36 years of life, he's been steadily employed, he's married, and a father of young children, and he's lived a productive life. The law says consider the fact that John has great family support, and a number of people are here today in support of John, filling this place up, and you've heard and seen letters in support of John Carter. They're character references. They're not speaking about the allegations in this case, but they're speaking to the character of this young man. The law says that the court should consider the fact that John has been supervised by this court since March of 2023 on pretrial services. Well over a year. He's been on GPS monitoring and has had a almost exemplary perfect supervision while that's been going on. The best indicator of how someone's going to conduct themselves is how they conduct themselves while the case is pending. And he's done an excellent job. And that's indicative of how he will do in the future and how he would do if he was given the opportunity to be on community control. The law says the courts should consider the recidivism factors. And I'm not going to go through all those that were in the sentencing memorandum, but when you look at those, they indicate that John is not likely to commit future crimes. The law says the court is to look at factors for the seriousness of the offense. And when you look at those factors, the majority of those predominantly show and evidence that this is not the most serious form of the offense. The law says using the minimum sanctions to accomplish the court's goals so as not to cause unnecessary burden on state and local resources. Community control is a lesser sanction than incarceration in prison. fewer resources would be used on that, and you could still accomplish the goals of protecting the public and rehabilitation, as well as punishing the offender. Your Honor, the law says John is amenable to available community control sanctions, and based on the aforementioned information already indicated, that's an appropriate sentence. The law evidences that if the court finds that community control is not appropriate, a minimum prison sentence would be appropriate. The law says furthermore that if a prison sentence is imposed, that a maximum sentence would not be appropriate based on all the factors to be considered. We ask the court to impose a sentence based on law and the sentencing guidelines, the purposes and principles of sentencing, not based on emotion. We ask the court to courageously impose a community control sanction or, in the alternative, a minimum prison sentence. Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, we will ask that, as there may be additional individuals that speak coming before you, that anyone that does come to speak address their comments to the court versus any individuals.
The court will indicate, as a matter of record, obviously, that I am the one that is going to be passing this sentence, and it would be most productive for anyone that intends to address the court to address their statements to me, as opposed to anyone else in the courtroom. Furthermore, the court, just so that the record is clear, Mr. Carter, it has been indicated that you do not wish to make a statement. I just want to confirm that that is in fact the case.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
On behalf of the state.
Yes, Your Honor. Your Honor. There's a favorite expression among lawyers that has pointed application to this case and the sentence Your Honor is about to impose. Justice delayed is justice denied. It applies because from the first suggestion by the defendant that Caitlin was, quote, missing until the first report 2 years later that her remains were found, this defendant knew where she was, how she got there, and by his guilty plea, his cause of her death. During each hour and day of that 2-year period, Caitlin's father suffered unimaginable pain and anguish by her disappearance, and as happens in such cases, he had to be ruled out as a suspect in her disappearance and death. From the date of her disappearance until the date Defendant Carter spoke the words to you and the world admitting that he caused her death, he put multiple law enforcement agencies and my office to the test to prove his responsibility and accountability for Caitlin's death and all the suffering he caused. That time and those resources cannot adequately be measured in mere dollars or what he took from Caitlin and all who loved her. His plea put an end to all doubt of his guilt that even a trial would not have accomplished. A successful trial would no doubt lead to seemingly endless appeals and his perpetual claims of innocence, lies, and alibi. The plea of guilty ended all that uncertainty with finality. Or has it? The defendant has given the court 29 statements from those who attest to the defendant's good character, but are absent any mention of Caitlin and the defendant's cause of her death. I called one of those personally to inquire and was told the defendant maintains his innocence and only pled guilty to avoid a harsher result than the one he faces today. The defendant thus lied about his innocence. Or did he lie to you concerning his guilt? If he did, we all need to get on with the trial. Everyone should know, however, that the defendant's attorney, Mr. Pagan, submitted a sentencing memorandum in which he acknowledges the truth of the defendant's guilt, and Mr. Pagan is an honorable man. he states, and I quote, "And he concedes," referring to the defendant, "the offense arose from their relationship," his and Caitlin's, end quote. This is the first acknowledgement beyond his admission in court that he caused her death and is absent from the pre-sentence investigation by his choice. It is noteworthy that no discussion of a guilty plea was ever entertained until the defendant's lead attorney approached my team weeks ago seeking a plea of guilty to manslaughter. There was never any suggestion of an Alford plea where a defendant's innocence can be maintained, but with acceptance by a defendant of a conviction to avoid a harsher result, as he claims with one of his character witnesses. The plea offered by defendant Carter was straight out guilty of causing Caitlin's death, a clear and spoken admission and desecration of a corpse that surely occurred by his hand, a delay for which he is responsible, and the injustice of that. The court now has before it the pre-sentence investigation where the defendant was given the opportunity to explain himself, to proceed on the road to redemption with a good act of contrition. Instead, as reported in the pre-sentence, he did neither and gave no account other than his admission to you of his guilt and that he caused her death, with no explanation to solve the mystery of how and why he killed Caitlin. That failure alone is a principal recidivism factor in favor of a maximum sentence, and for all those unanswered questions and all the grief and sorrow he caused, he deserves the maximum sentence available under the law that no one should find just or justice for Caitlin. His ultimate plea surely was not to assuage the pain he caused and garner some benefit of accountability. Defendant Carter had the benefit of 3 skilled attorneys, and with them a risk-benefit analysis of the trial about to take place, and the conclusion a jury would make in the battle between circumstantial evidence and coincidental evidence. After 13 years of unanswered questions and 18 days before his trial would commence, he made an unqualified admission of guilt. All that he deserves now is to serve every day from this day of the maximum sentence I ask you to impose. Thank you, Your Honor.
Thank you so much. I understand that there are members of the family that wish to address the court.
Yes, Your Honor. A couple of other matters. There are approximately 55 victim impact statements I believe the court has received. There is one statement that I believe was signed by 120 individuals. I think there was another victim impact statement that was signed by approximately 150 individuals. I do believe there are 2 individuals that wish to address the court. David Markham, the father of Caitlin Markham, wishes to address the court, and Tina Barrett, who is represented or is representing the Markham family throughout this whole ordeal. So, gentlemen, would like to speak first. I think the court would probably want like one at a time.
Yes, yes, and the court will make clear.
As his counsel?
That's fine, that's fine.
I believe the court.
That's fine.
That's fine.
I will make clear as a matter of record that the court has taken the time to read each and every one of the victim impact statements that has been offered. They came in at various times over the past several weeks. The court has also, as indicated before, taken the time to read the letters that were offered in mitigation on Mr. Carter's behalf as well. Mr. Martin.
Your Honor, I could go on and on about how painful. Every Christmas, birthday, the date she was found for the past 13 years. The bizarre phone call I received from John screaming in my ear that Caitlin is missing. The odd 911 call. I watched John attend searches and visual candlelight services, knowing that he knew exactly what she was doing. Dating her best friend, having children with her, and then marrying her. Yes, the pain and anguish are real. The worst nightmare a parent ever dreams will happen to them. Your child goes missing. That happened to me and lasted nearly 2 years before she was located. And she was located in a pile of trash. The action displayed by John as she was tossed out like garbage. The lack of human respect by John is disgusting and scary. John has no respect for anyone, only looking out for himself. I hope there's no one else next. It is very heartbreaking knowing someone treated your child with such disrespect and the impact it has on your child and her sister. Allie was and is devastated. She wanted to be an aunt, but John Carter took that away from her and proceeded to live his life as if nothing had happened. Not a day goes by that I do not think of Caitlin. She had talent, dreams, and was making a name for herself. She was a bright, bubbly young woman, and it hurts knowing I do not get to see her blossom. See all the wonderful artwork she would have produced. I am so proud of her and looked forward to a wonderful life with my 2 girls. John Carter took that away from me. John has caused so much grief and pain for my family, my friends, the community, and myself. The most recent event happened just a few weeks ago. Allie walked into a Home Depot and John was there with his family. How horrific for Allie to have to see the person who murdered her big sister was there living life. John pled guilty, but was still free. Allie has that fear every time she goes in public that she may run into John Carter. Your Honor, I implore you to sentence John Carter to the maximum allowed by law. I do not feel 3 years is justice. Not for Caitlin, not for her sister, not for me, her friends, and the entire community that has ached and grieved alongside of us. John Carter is not a nice person. The only remorse he has ever shown is when he feared he might face prison. Let him feel the pain that so many of us have endured for the past 13 years. Thank you, Your Honor, for your time and consideration.
Thank you, Mr. Mark.
Your Honor. Tina Barrett on behalf of the Markham family, and I would like to start by reading a statement from Caitlin's sister, Allie Markham. Judge Boyd, my name is Allie Markham, and I'm Caitlin's little sister. I was 15 when my sister went missing. I am now 28, older than Caitlin ever got to be. Putting my thoughts and feelings into words has proven to be very difficult for me. I have shied away from the media and found it very difficult to open up about the pain I've experienced, even with my friends and family. As I was just entering high school when everything happened, I feel John Carter stole the last years of my childhood and most certainly changed my life forever. For almost 2 years, I had hope that Caitlin was still alive. I wondered where she was and what she could possibly be going through. At 15 years old, I thought about the possibility of my sister being trapped in someone's basement, being tortured, and trying to escape. I had nightly dreams that she would one day come home like nothing happened, and everything would go back to normal. But as we know, that didn't happen. Instead, I watched my parents' lives be shattered. We all tried to navigate holidays, milestones, everyday life without Caitlin. I lived with the guilt that maybe if I had been there that night, this would not have happened. John Carter and his mother actually planted seeds of doubt that it was my fault for not locking the downstairs window, possibly allowing an intruder to get at Caitlin. Only to find out 13 years later, the intruder was him. I watched John Carter hug my dad and try to console him, knowing Caitlin was never coming home because he had killed her. During the search for Caitlin, John lied to me. He reassured me that everything was going to be all right. He told me he was journaling and he planned to share the journal with Caitlin when she returned. He said they were going to laugh together about how people were treating him and accusing him of doing something to her. In that moment, John saw a teenage girl upset because her sister was missing. And he chose to manipulate her to better his own image. He knew he would never be able to share that journal with Caitlin, if there even was a journal, because he had killed her and he had hidden her body. John took so much away from this world when he ended Caitlin's life that night. He stole the sunshine she would bring to any situation. He stole her contagious laugh. He stole her amazing talent. Talent that Caitlin never got to develop. Caitlin had to miss out on so many opportunities because of John's selfish actions. Even if whatever happened that night was an accident, covering it up and lying for 13 years was most certainly not accidental. John has never been concerned for anyone but himself. He has lied, manipulated, and tortured Caitlin's family and true friends for over a decade. John Carter is responsible for killing my sister, dumping her body like trash, and lying to the world for 13 years while he continued to live his life. He is not a victim. I believe the least he deserves is to sit in a cell, alive and uncomfortable, for 3 years. And that is from Allie Markham. Your Honor, I have another statement that is prepared on behalf of the Markham family from both a personal and also a third-party perspective that they would like to have shared with the court today. Your Honor, John Carter he treated her death exactly the way he wants you to treat his punishment here today, with a focus on him and his needs. In that he is consistent. He knew she was dead, and instead of allowing her family ability to grieve for her and bury her and honor her memory by telling them she was gone, he let them suffer and compounded their suffering with the lies he told to keep himself from having to explain what happened that night. If John Carter caused Caitlin's death while committing a misdemeanor crime and therefore is guilty of involuntary manslaughter, as we all know, because he made that plea and this court accepted that plea, then he knew she was dead because he was present when she took her final breath. When he called Dave Markham screaming, "Caitlin is missing," he was lying. When he called 911 and said, "My fiancée is missing and I can't find her anywhere," he was lying. When he spoke to the media and told the story of texting with her that night, sending good morning texts and becoming worried and freaked out because she wasn't responding, he was lying. If Caitlin Markham had actually returned his messages that morning, he would have freaked out because he knew she was not going to bed when he left her that night. He knew she was deceased. For 2 years, he continued to lie while Dave Markham went to bed every night terrified that his daughter was somewhere suffering and needing him and wondering why he was not there to help her. Allie Markham finished out her childhood wondering if she'd ever know what happened to her sister. And the lies did not stop there. John Carter continued his charade of being a victim in this whole thing, pretending not only did he lose the love of his life, but people were being mean to him by suggesting that he had something to do with it. Instead of telling Dave Markham what really happened to his daughter, John Carter went on with his life, had children, bought a house, and got married. And now, 13 years later, John Carter, through able counsel, wants you to consider all that he has done to build a good life as evidence that he is worthy of leniency. The problem is, that's just one view, the view from John Carter's eyes. Everything he's done for the past 13 years has been built upon the suffering of others. Those 13 years are built on lies, deception, and cruelty. His ability to move on was at the cost of Caitlin's family's ability to move on. of not being held hostage, not only by the grief of the loss of of the child and their sister, but by not knowing what happened to her. And the continued farce that it was all just a big mystery to John Carter. He has no history of good behavior, unless you count the day he said guilty. But even then, his tears were for himself. He has no remorse for Caitlin Markham or her family. The punishment for this crime carries the potential of 3 years in prison or no prison at all. Because we as a society understand that circumstances matter. Today, we ask this court to consider the circumstances, but not only from the perspective of John Carter. We ask the court consider the view Caitlin's family and friends have had for the past 13 years. That view has been full of deception and disrespect. That view does not call for leniency. There is a range of potential punishments for a reason. John Carter deserves the harshest punishment this court can impose because he has earned every bit of it. Nothing else on behalf of the family, Your Honor.
Thank you, Ms. Barrett.
Thank you.
Nothing else on behalf of the state line.
Thank you, Mr. Burris. The court certainly agrees with the assessment that we're obligated to follow the law. I think every court would certainly agree that we are bound to the law as it is set forth. And in this particular case, as with any felony case, there are factors that the court must consider. Of course, in the consideration of those factors, it's not simply a mechanism. It's not a computer that ultimately arrives at what is a just result. It's men and women that serve our communities as judges that have to use their sense and their sensibilities in navigating the way that the law is written to find a result that in some way, shape, or form arrives at justice. And many have said that in this particular case, whatever this court might do won't be just, because the punishment won't possibly serve the interests of making right or even beginning to make right the loss of life that was the basis of this case. And certainly from the defendant's perspective and the many letters in support that champion his cause, that aside from the incident that brings us before the court today, that Mr. Carter has led an otherwise law-abiding life. The court does find, as was indicated during Ms. Barrett's statement, that those assertions have to be taken through a lens of the facts of this particular case. And when the court looks to the sentencing factors that it's obligated to consider, it has to look at it through the lens of this case. To that end, as the defendant states in the sentencing memorandum, it is clear that there are serious physical harm, is the most serious physical harm that the court could possibly consider, the death of the victim. The court also considers that the offender's relationship facilitated the offense, and that was never in question with respect to the relationship that existed and has been acknowledged both in the letters on behalf of the Markham family as well as the letters on behalf of Mr. Carter speak to the nature of this relationship, the loving, caring relationship that existed between these two people. And of course, we see that on all too regular a basis in courts throughout Butler County, the state of Ohio, and everywhere. The domestic violence and the types of acts that take place behind closed doors are tragic. Tragic. That they come out of these relationships that are supposed to be built on love and trust, and that's not where they end. The court agrees that Mr. Carter has no criminal history aside from the case that's before the court today. The court does take exception, however, with the assertion that when we talk about the recidivism factors, that none apply to Mr. Carter. The court believes that Mr. Carter has shown no genuine remorse for this offense. And that is exhibited through the fact that if we look at this through the lens of the charge to which he pled guilty, that essentially this was in the eyes of the law, as it would apply to that particular charge, a misdemeanor offense gone horribly wrong with an unintended consequence of the death of a loved one. What is the reaction that a human being would have? It was a shoving match, it was an assaultive behavior, it was some type of a misdemeanor offense with no resulting death intended. When does the call come? Begging for help and assistance. When does the acknowledgement come that this person that I've loved, that I've caused their death, that her family needs to know, that the community needs to know, that they don't need to be constantly in fear that there's some madman on the loose that would break into random apartments and attack anyone and everyone in the city of Fairfield. Ultimately, there was a plea, and there was some degree of responsibility that was accepted by the defendant, but it was calculated. The cost-benefit analysis that the state offers rings true with the court. The lack of any true explanation in the body of the pre-sentence investigation or otherwise, the court finds it disingenuous to believe that there can be genuine remorse without acknowledgement of what took place. Counsel, if you and Mr. Carter would please approach the podium. The court has considered the record and overriding purposes of felony sentencing to protect the public from future crime and to punish the offender and promote the effective rehabilitation of the offender, using the minimum sanctions needed to accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the seriousness and recidivism factors set forth in Ohio Revised Code sections 292911 and 292912. I considered the information contained in the pre-sentence investigation, as well as the victim impact statements and the mitigation statements that have been offered to the court. I have also considered any and all statements that have been made at this hearing. In light of those considerations, the court imposes the following sentence. The court finds, based upon the serious nature of this offense and the factors that have previously been indicated, that anything short of the maximum sentence would demean the seriousness of the offender's conduct and its impact upon the victim, and therefore will impose a definite term of incarceration of 36 months. There are 14 days of jail time credit to which the defendant is entitled. Being that the court has imposed this sentence, there is also a mandatory period of post-release control of a minimum of 1, not to exceed a maximum of 3 years. If you violate the terms and conditions of post-release control, the parole authority can return you to prison up to 9 months per violation up to 1/2 of the original sentence. Also, if you commit another felony offense while on post-release control, the sentencing court could sentence you to prison for an additional year or the time remaining on post-release control, whichever is greater, just for committing the new felony offense. That time would not be included in any sentence on the new felony conviction itself. Do you understand that, Mr. Carter?
Yes, Your Honor.
The court has considered your financial resources and your ability to pay financial sanctions both now and in the future. The court will order that you pay court costs. If you fail to pay the costs associated with this case, the possibility exists that you'll be ordered to perform community service work and given credit towards the outstanding balance for each hour of community service performed in an amount equal to the then existing amount of minimum wage in the state of Ohio. I note for the record that there was no restitution that was requested in this case, as the court was made aware that funeral expenses were taken care of by a third party. Mr. Carter, you have the right to appeal the sentence in this case. You do that by filing a notice of appeal with the clerk of court for Butler County within 30 days. If you're unable to pay the costs of the appeal, you have a right to appeal without payment of costs. If you're unable to obtain counsel for an appeal, counsel will be appointed without costs. If you're unable to pay the cost for the documents necessary for the appeal, those documents will be provided without cost. If you wish to have a notice of appeal filed on your behalf, you simply need to instruct your current trial counsel to file that, and then ultimately, if it's retained counsel, they'll handle that issue, and if you need counsel appointed, they'll have you fill out an affidavit so that the court can appoint counsel if that becomes appropriate and necessary. Counsel, anything else that you wish to place on record?
No, Your Honor. Thank you.
Mr. Carter is ordered remanded to the Butler County Jail pending his transfer to ODRC.
So John Carter pleads guilty to his fiance's murder and is sentenced to 36 months behind bars, which is the maximum that they can give him because of a plea deal. My question remains. You can drop your comment in the comment section or in the community or on the community section on my poll. The question still remains: was justice served? I'd like to hear from you on that one. In the meantime, we're going to move onward. Just a little bit ago, I mentioned that Brandi Nicole Elliot has a legal battle coming her way on top of the murder charge that she drowned her daughter simply because she wanted time alone. Now, let's get this out the way. The question asked to start off this article: how could a mother drown her own child? Brandi Elliot will somehow have to explain that to a jury, or she could face the death penalty. Ooh. Elliot may have no choice but to draw from the tragic case of Lindsay Lowe, another Sumner County mother who killed her children. It's almost eerie that something like this has happened before. In Sumner County, Lowe smothered her newborn twins. Now, more than a decade later, Elliot is charged in the murder of her 7-year-old daughter. Now, guys, you have just saw me in a brief discussion with my wife talking about this case, and she's still upset. She's so upset. She's waving at me right now. Don't bring me into this conversation no further. And I'm not. But I'm gonna go on and continue with the article, and just know, she's not the only one ticked off about this. In 2013, Lo was sentenced to life in prison. This after confessing to police she smothered her newborns to death. This past Saturday, which was last Saturday, Elliot admitted to Hendersonville police that she held her daughter Piper's head underwater, and the child later died at the hospital. She's charged with first-degree murder. The jury will want somebody to be responsible for the death of this child, said Script News Nashville's legal analyst Nick Leonardo. He added that if the case goes to trial, Elliot will face the same challenge Lo did with the jury. Clearly, an individual charged with killing their own child will have mental health issues. The question is, does that rise to the level of providing a defense, he said. Like Lo, Elliot's only defense may be to argue diminished capacity, that she was out of her head when committing the crime. She alluded to mental illness during her first court appearance this week. Let me stop right there. First of all, guys, I am almost sick that every time a murder case has gone down, a murder defendant is claiming mental health issues to the point that they're incompetent to stand trial. Yes, I'm talking about you, Bionca Ellis. They're using that excuse to where they will not stand trial, or they want to use that as a defense to make sure that they end up in some type of mental facility instead of behind bars. Think about that. When my daughter was 2, I kind of lost it like I did this time, and I have had depression and they gave me medicine for it, Elliot said. That was 5 years ago. But Elliot also told the judge she was not currently under the care of a mental health professional. Friends said she seemed like a loving mother and can't explain why she would hurt her daughter. I really don't know. I don't understand, said Deanna Sartain. Lo's attorneys argued diminished capacity at the trial, and the jury returned a guilty verdict only after a few hours of deliberation. Yet another Sumner County jury may now hear the same defense. It remains to be seen if they'll reach a different verdict. Prosecutors did not seek the death penalty in Lo's case. They have yet to decide if they will for Brandi, Nicole, Elliot. I'm trying not to shed tears over this case because of how sad and how tragic it is. But if you're trying to compare apples to apples, I see the same thing happening as Lo's case. Let's go back real quick. Lindsay Lo smothered her newborn twins. She tried to claim a mental health defense. The jury came back within a few hours, bam! guilty. And she's doing time behind bars for it. Now, we've got Brandi Nicole Elliot, who allegedly drowned her 7-year-old daughter. All because she wanted time alone. She had a bad day. Most parents have bad days. That doesn't mean they're gonna take their 7-year-old and drown them to death. You gotta be kidding me. I'm telling you, it's gonna be wash, rinse, repeat, insert new defendant. The new defendant in this case is Brandi Nicole Elliot. Everything else, wash, rinse, repeat. Wash. She's going on trial for murdering her 7-year-old daughter by drowning. Rinse. She's gonna use a mental health defense. The repeat is that the jury is going to deliver. Is my prediction. No, I think I'm gonna go full on Paul Heyman with this one. Here's what's gonna happen. After all the testimony is done, the jury is going to deliberate. It will only take them a few hours. When they come back, they'll come back with a guilty verdict. And when the time for sentencing comes, it will be Brandi Nicole Elliot who will be spending time behind bars. And in the words of Paul Heyman, that's not a prediction. That's a spoiler. And to wrap that statement up like Stone Cold Steve Austin would say, that's all I gotta say about that. Next up. Earlier, I had a case where I can tag it justice served with a question mark. This next case, I can tag it with the words justice served with an exclamation point on it. A scare actor is sentenced for savagely mutilating his best friend. You know the saying, with friends like those, who needs enemies, right? So, I'm gonna mute out. I'm gonna step out of the shot, and I'm gonna take you directly to my good friends at Court TV, Michael Ayana and the Honorable Judge Ashley Wilcott, as we cover the sentencing of Brandon.
I want to get you back to the sentencing hearing in the scare actor murder trial in Georgia. The judge is now ready to hand down his sentence.
First, I want to acknowledge all the family and friends that are present in court to support not only Aaron Davis, but also the defendant, Brandon Reisner. Both of these young men have been loved throughout their lives. And I know all of you are experiencing tremendous pain, including the Reisner family. But the pain of Aaron's family far exceeds that. To have a young son brutally murdered is unfathomable. I hope that your fond and loving memories of Aaron and that your faith will provide you some comfort as your life continues. Having said that, I have considered all of the facts and circumstances of this case and counsel's arguments. And I have come to the conclusion that justice requires that Mr. Reisner be sentenced on count 1 to imprisonment for life without parole. And that's what I'm going to do. And that's based upon the premeditation, the manner of death, and the efforts to cover up all of the acts. On count 2, felony murder, that will be vacated by operation of law. Count 3, to which Mr. Reisner also pled guilty, will be vacated by operation of law. Count 4, the aggravated assault, will be merged into count 1, as will count 5, aggravated assault, and count 6, aggravated battery. Count 7, concealing the death of another, the sentence will be 10 years. Count 8, abandonment of a dead body, there will be a sentence of 3 years. Count 9, theft by taking a motor vehicle with a value more than $5,000, the sentence will be 10 years. Count 10, removal of body parts, be a sentence of 12 months. Count 11, tampering with evidence, be a sentence of 10 years. And count 12, obstruction, that's a misdemeanor, the sentence will be 12 months. So the total sentence is life imprisonment without parole. Did you want to add something, Ms. Mayo?
Your Honor, count 11 is a misdemeanor. You had said 10 years.
Count 11,
yes,
tampering with evidence?
Yes, sir.
Well, I thought I looked that up. Okay. That will be a sentence of 12 months as opposed to 10 years. The sentence speaks for itself. God bless everybody in the courtroom.
Oh, Your Honor, would you include a condition of no contact of any kind?
All right, so there you heard it. The judge sentenced Brandon Reisner to life in prison without parole. He goes through a number of charges, adding years for things like aggravated assault, aggravated battery, tampering with vehicle, tampering with evidence. But those don't really matter. They've kind of merged, and he's in jail for the rest of his life.
And Michael Ayala wrapped it right up at the very end. The bottom line is Brandon Reisner, sentenced to life without the possibility of parole. He is going to be in there for the rest of his life, and which is why I ended that with the words "justice served" with an exclamation point. Next up, plea date rescheduled for Katrina Bauer, the mom of missing 3-year-old Elijah View, who was reported missing all the way back in February. All the way back. And you know what? What the sad thing is? He's still missing, and mom and her partner is still not talking. A plea date has been rescheduled for Katrina Bauer. She's the mom of missing 3-year-old boy Elijah View, who was reported missing from Two Rivers back in February. She has been charged with child neglect, but has not been charged in the disappearance of Elijah. During court on this past Thursday in Manitowoc County, Bauer's attorney said she's asking for the delay because there were issues that still need to be investigated. Bauer's attorney could not immediately be reached for comment after court. The plea date is now scheduled for July 26th. While they're playing around with these plea scheduling dates and blah blah blah, Elijah's still missing. Elijah is still missing. I guess I gotta put the information out there again through Nick, I believe, or maybe I can go through the FBI's information, because honestly, guys, this is making absolutely no sense whatsoever. There we go. Alright, so let me take you to that page real quick, give you that information again, and let me get Same, as I said for the other missing persons cases that I started today with, I say with the utmost urgency with Elijah. If you see something, say something. That way, we can do something. Meanwhile, like I said, Elijah's mom or her partner is not talking. They're not talking. They rather plead and go to jail than to say where Elijah is. Think about that. Next up, we have a verdict in the mother's witchcraft murder trial. Iowa versus Tyler Daisy. Alright, let me go ahead and get you set up here. Okay, an Iowa man is facing life in prison after being convicted of murdering his mother and the family dog. On July 19th, a 12-person jury found 29-year-old Tyler Daisy guilty of first-degree murder in the death of 46-year-old Jennifer Daisy. He was also convicted on charges of animal abuse for killing his mom's dog, Echo. Let me get out the shot, and I'm gonna turn you over to the Honorable Judge Ashley Wilcott for coverage of this verdict.
Turning now to Iowa, where a verdict has just been reached in the mother's witchcraft murder trial. Tyler Daisy is accused of murdering his mother, Jennifer, and the family dog, Echo, back in January. He later told police that it was because his mother had been practicing witchcraft. Daisy was not in attendance during his brief 3-day trial, writing a letter to the judge saying he would not be participating. He also was not in court for the verdict. But before we take you into court for that verdict, here's more on the case against Tyler Daisy. January 18, 2024, Christy Fullman finds the bloodied body of her friend and neighbor Jennifer Daisy lying motionless in her bed.
They're on the way right now. There should be an officer coming up right now. Yep, they're coming.
Christy had let herself into Jennifer's house for an early morning coffee date. She became alarmed when Jennifer's dog, Echo, didn't jump up to welcome her.
Hello?
According to the police report, Jennifer had numerous lacerations to her face, neck, and head, and 2 of her fingers had been severed. Echo had died from a blunt force injury to his head.
I hightail booked it out of there and ran into the officer. And I asked him, don't leave me, don't leave me.
Jennifer's 29-year-old son, Tyler, was the only other person in the house. Police found him lying on the floor in another bedroom.
He's breathing.
Tyler Daisy was arrested and charged with first-degree murder and animal abuse in the deaths.
I circled around to the front of the residence and noted that Tyler Daisy was in fact the person they had in custody, Mr. Daisy, who was face down on the ground and was naked.
Did you ask him about his relationship with his mother?
I did. His response was, it's fine, except for when she's acting sneaky like a witch. He then went on to talk about how his mother was part of a covenant of witches.
Prosecutors say they found Jennifer's blood and Tyler's palm print on a hatchet that was found in the house. His defense team urged the jurors not to rush to judgment and to carefully consider the evidence.
I told him he was being arrested for the murder of his mother. His response was, it's hard to argue witchcraft in court, isn't it?
If Tyler Daisy is convicted, he could be sentenced to up to life in prison. Daisy again declined to be in court today for the reading of the verdict, but let's go in and see what the jury decided.
Okay, this is the state of Iowa versus Tyler Daisy, FECR 153723. As to count one, on the charge of murder in the first degree, we, the jury, find the defendant, Tyler Daisy, guilty of the crime of murder in the first degree. That verdict form is signed by the foreperson. As to count two, on the charge of animal abuse, we, the jury, find the defendant, Tyler Daisy, guilty of the crime of animal abuse, and that verdict form is also signed by the foreperson. Is the state asking that the jury be polled? No, Your Honor. Is the defense?
We better, Your Honor.
Okay, so folks, the court attendant will poll you by reading your juror number. When she reads your number, she'll ask whether you can confirm that this is in fact your verdict. Go ahead.
Not at all surprising, based on the evidence presented, that this jury found him guilty of both charges beyond a reasonable doubt.
Nothing else needs to be said. Tyler Daisy, guilty. Murdering his mom, guilty of killing the family dog. Now we await for sentencing in that trial. Finally, we wrap up this week's legal news. And before I go to Julie Grant with her statements for the week, we wrap up with an update on Harvey Weinstein. Harvey Weinstein, his retrial I should say, is tentatively set for November. Let's go to Judge Ashley.
We have breaking news out of New York, where a judge has tentatively scheduled the retrial of Harvey Weinstein. The Hollywood mogul will go on trial again on rape and sexual assault charges on November 12th. New York's highest court threw out Weinstein's 2020 conviction earlier this year. The appeals court ruled that the original trial judge unfairly allowed testimony against him based on allegations that were not part of this case. Weinstein was in court today and wore an American flag pin on his lapel. He continues to deny any wrongdoing. But again, the breaking news: his retrial has now been tentatively scheduled for November 12th. Of course, Court TV will keep you posted with any updates.
As always, when I get those when they get those updates, I'll get those updates. And when I get those updates, you will get those updates. Right here at the drama-free true crime destination. Now, I'm gonna close out like I normally do with 5 statements from Court TV's Julie Grant. I will begin with her opening statement regarding the bungled mess, her words not mine, in the Alec Baldwin manslaughter trial. And believe me, it was such a bungled mess. It was such a bungled mess, ladies and gentlemen, that the judge had no other choice but to dismiss the whole thing. With prejudice, in fact. So, I'm going to stop talking, and I'm going to let Julie speak her piece.
What a bungled mess. I've said it before, and Friday's dismissal said it even louder. The Rust case was bungled, and now the fallout continues. Get ready for Hannah Gutierrez to get a new trial now. And she should. Because the failure to test those rounds and disclose that new information affects her legal position even more than it did Alec Baldwin's. I recently heard the expression that oftentimes people's problems bear their own fingerprints. And here the state of New Mexico have themselves and themselves only to blame for this bungled prosecution. Those investigators made a choice to sit on potentially exculpatory evidence. The lead prosecutor, Carrie Morrissey, made a choice to determine what she felt was relevant and to ignore evidence that she deemed irrelevant. Friday morning, my friends, I told you what happened was appalling, and the court agreed. Potentially exculpatory evidence always must be turned over to the other side. Public servants don't get to pick and choose and hide something that could potentially free the accused. Look for Hannah Gutierrez to go on trial again. I would bet my bottom dollar after hearing the judge's opinion on Friday, that will happen. But what I'm not so sure about is whether the state's eyes have been opened to anyone else's potential involvement. Will anything change with Seth Kenney? What about with Sarah Zachary, the film's ammunition supplier and the prop master, respectively, who Hannah Gutierrez reported to? Will they face any criminal liability? I can't wait to see how those questions will be answered. In the meantime, I wish victim Helena Hutchins' family members comfort and peace. Because yes, this case turned out to be a bungled legal mess, but we'll never forget the beautiful life that was lost in this tragedy.
No, we'll never forget that. That's usually why a lot of people get into true crime. It's not about just going case after case after case, but it's about seeking justice for the victims. Speaking of victims, we were getting prepared to hear testimony from Marsha Thompson, but the question remained, and it still remains as we speak. Is she a victim of domestic abuse, or is she a cold-blooded murderer? As I'm setting this up, Julie's going to recount how terrifying cases of domestic violence can be. And the question asks, does it matter how a husband is killed if he is the abuser? Strap in, folks. Here comes Julie's second opening statement.
Crimes of violence and crimes of secrecy. That's what makes domestic violence cases so terrifying. You never really know the full extent of what somebody is suffering through unless you witness it. It is a terrifying dynamic that happens between an abuser and their victim. And they take their victim through a very complicated cycle where it's not all bad. There are tremendous highs and promises, lots and lots of promises to stop the violence. And these good times make it really difficult for a victim to want to leave because they love their abuser. They just want the violence to stop. And when they see it stopping, they become encouraged. There's also something called a trauma bond that forms through that push-pull in that cycle of domestic violence. It's not just physical abuse either that happens. It's also mental and emotional abuse, sometimes financial abuse as well. And suffering through it all can have devastating, and I mean devastating effects on a person's health. Battered person syndrome is just one of the terrible things that can happen to a victim of domestic violence. And I'm thinking about it this morning as we're watching the case of Marsha Thompson. I don't know what the outcome will be, but I know I am very disturbed about the facts. Just hearing how much she suffered at her husband's hands just during the opening statement had me thinking about it all day. What happened to Marsha Thompson during her marriage is sadly all too common. And I'm a big believer in talking about it as a means of preventing it. Because the more educated we are in the dangers, the effects, the reasons that it's not so simple for victims to just leave, the better off we will be in saving lives. So if you are experiencing domestic violence, know that you're not alone. Know that you have done nothing wrong. And know that there is a safe way out. Call the National Domestic Violence Hotline, 1-800-799-SAFE or 7233.
And right at the very end is something I totally encouraged. You do not have to be another statistic of domestic violence. Help is a phone call away. Again, that number is 1-800-799-SAFE. 1-800-799-7233. That line is open 24 hours a day in over 150 different languages. You can get help. And now, Julie's next statement could be on questioning what Marsha Thompson would actually say regarding the death of her husband. Again, the question remains: is Marsha Thompson a cold-blooded murderer, or is she a victim who just simply fought back? Ladies and gentlemen, Wednesday's opening.
What might she say? Marsha Thompson will likely be taking the stand in her own defense. What will she share about her relationship with her husband, Terry? What will she share about that dreadful day that she shot him 9 times? The prosecution is painting a picture that she is a cold-blooded killer. They've established that Terry Thompson was on the couch resting. Investigators found his sleep apnea machine beside him. There was a pillow on him, a laptop and a blanket on the couch too. The state's forensic experts say that Terry Thompson was laying on his back when he was shot and killed. Was this a cold-blooded execution? Or was this a justifiable homicide? The jury will be deciding what happened in the couple's home back in August of 2019. And today could possibly be the day where we hear from Marsha Thompson herself. If I'm on that jury, I'm going to be scrutinizing her every word and her every movement. If the jury believes her, that she really and truly was in fear for her life when she killed him, she could walk away a free woman. Because only 2 people know the absolute truth of what occurred in that home during that heated argument. One of them is deceased. The other one may get a second chance at life, depending on what happens if she testifies. Everything rides on her believability. If we hear her tell her truth, we may be a giant step closer to getting to the truth of this very troubling and tragic case.
it takes. And I believe deep down in the phrase, the truth will set you free. I'm gonna take a break from Marsha Thompson long enough to hear Julie's statement on the possibility of Hannah Gutierrez getting a new trial or even having her charges dismissed. Now, I'm no legal expert by any means, but I do agree with this statement regarding justice for the victims. You've got to go also with the rules of evidence. If you have the evidence, both sides needs to see it. Hey, but don't argue with me. Don't argue with me. We have a word from a former prosecutor who knows exactly what she's talking about. So without further ado, this is Thursdays.
What is justice to you? I get asked that question all the time, especially when I was a prosecutor. And my answer is the same now than it was then. Justice is doing what's right. When you take an oath to serve the people of your state or commonwealth, you get the chance on every single case to do the right thing. Sometimes the right thing is withdrawing the charges. Sometimes it's amending the charges to better fit the facts of what really happened. Your job as a prosecutor is not to get convictions. No, your job is to follow the rule of law, the rules of evidence, the rules of criminal procedure, and the rules of professional responsibility. Bottom line, you do what's right. At the very least, Rust movie armor Hannah Gutierrez deserves a brand new trial. At the very most, she deserves a dismissal for the same reasons the judge dismissed Alec Baldwin's case. What's more, in Hannah's case, there was far more than just the state sitting on the live rounds. There's a list of other evidence not disclosed. Most importantly on that list, helpful statements made by the ammunition supplier, Seth Kenny, that were never turned over. And a helpful report from the state's firearms expert pertaining to the trigger. That was never turned over either. There's no excuse for that. Holding back exculpatory material is against the law, the rules of evidence, the rules of procedure, and the rules of ethics. My biggest question is why? Why were these critical pieces of evidence not disclosed to Hannah Gutierrez for her defense? Because she was entitled to them. And now she's entitled to a remedy. And because there's even more in her case than was withheld in Alec Baldwin's case, I won't be surprised if the judge dismisses her case entirely for the same reasons that she did his.
And I gotta agree with Julie on that. If the judge in Alec Baldwin's case is gonna dismiss his case with prejudice, mind you, for those reasons, Hannah Gutierrez should get a new trial at the least, or at the most, get her charges, her conviction dismissed. What's fair for one is fair for all. That's, ladies and gentlemen, is justice. All right, we're gonna wrap this up with a statement of going back to the Marsha Thompson trial And she's going to tell you that intimate partner violence is tragic on many levels. It's a problem all too common. But at the same time, and this is a statement that I'll agree with, there is no shame in being a survivor. No shame whatsoever. In fact, being a survivor gives you all the ammunition you need to tell somebody else, if I survived, you can too. So without any further delay, I'm gonna bring you to Julie's final opening statement for this week.
No shame. There should be no shame when you've been abused by an intimate partner. But sadly, there is. Shame in coming to terms with being in an abusive relationship. Shame in talking about it. Shame in asking for help. The feelings of shame can be overwhelming and also stifling. I'm thinking about this because of what I heard defendant Marsha Thompson say on the witness stand. She felt a lot of shame, especially regarding the sexual abuse that her batterer inflicted on her. Marsha Thompson is not alone. Intimate partner violence is a problem that is all too common. Feelings of shame, even though you have nothing to be ashamed of, can hold you back from reaching out to professionals for help. I don't know what this jury will decide. I know that the facts are tragic. And what I really know is that by supporting survivors of domestic violence, by making them feel comfortable, empowering them when they share their stories, applauding them and not judging them, we can help alleviate those feelings of shame. We can show them encouragement and help them see that the only people who should really feel shame are the batterers. The despicable, rotten, pathetic people who use violence to exert power and control over the people who love them. Shame on them. There's no shame in being a survivor. There is no shame in asking for help. There's everything to be admired about getting help, getting out, and getting healed.
I totally agree with Julie's last statement, and again, I say, if you need help getting out, if you need help getting that help, you're just a phone call away. Again, I bring you to the National Domestic Violence Hotline, and that number, once again, is 1-800-799-SAFE. 1-800-799-7233. There is help available. You don't have to be a statistic. My thanks to Julie Grant for those opening statements for this past week, and you can follow her on X, formerly known as Twitter, at JulieCourtTV. That's gonna wrap it up for me here, Bethea'S Byte Reloaded. I want to thank you all for watching me. I want to thank my replay gang for following me, and I'm all over social media. So if you need to get a hold of me, I'm on Facebook at Bethea'S Byte Reloaded. I'm on X, formerly known as Twitter, at EKB316, all capitals. I'm here on YouTube at Bethea'S Byte Reloaded. I'm on Instagram at EKB316, all lowercase. I will have a link to this edition of Bethea'S Byte on my TikTok page at King of Hearts 316 2021. And you can also email me. My address is kingofhearts316_09 at outlook.com. Also, if you want to support the channel financially, that would be a great help. You can hit me up on PayPal at PayPal EKB316, on Cash App $EKB316, or Venmo EB the Last Outlaw. Nothing's obligated, but it's always appreciated. Alright, but still, if you still want to do the free way to help out, which would be great too, you can always like, share, subscribe, and drop me a comment. I'll appreciate all that assistance. Alright, so I'm gonna wrap this up. I'm gonna thank you all. I appreciate you. This is the home for true crime news without the drama, where your opinions matter, lively debates are encouraged, your voice is heard, and above all else, here, justice is served. Ladies and gentlemen, you know where you are. This is the drama-free true crime destination. This is Bethea'S Byte, and it's reloaded. I'm Ernest Bethea, the Last Outlaw. Thank you all so much. I appreciate you. Let's do this again, same time, same place. You know where you are, and you know what to do from here. Bite this. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe, and drop me a comment on this video. And be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.